Good morning, everyone. I call the joint meeting of the Courts and Justice Committee and the Public Safety Committee meeting to order. Madam Clerk, please call the roll.
Thank you, Madam Chair. Members of the Courts of Justice Committee, Chair Herring.
Here.
Vice Chair Watts.
Here.
Delegate Hope.
Here.
Delegate Simon. Delegate Simon. Delegate Lindsay.
Here.
Delegate Sullivan.
Here.
Delegate Levine.
Here.
Delegate Heretic. Delegate Heretic. Delegate Mullen.
Here.
Delegate Bourne. Delegate Bourne. Delegate Delaney.
Here.
Delegate Carol Foy. Delegate Carol Foy. We'll come back. Delegate Scott.
Here.
Delegate Kilgore.
Here.
Delegate Bell. Delegate Bell.
Here.
Delegate Ranson.
Here.
Delegate Leftwich.
I'm here. I'm here.
Delegate Adams of Pennsylvania.
Here.
Delegate Campbell of Smith. Delegate Collins. Delegate Collins. Delegate Miares.
Here.
And Delegate Campbell of Rockbridge.
Here.
And now calling the roll for members of public safety. Chair Hope has acknowledged his presence. Delegate Bourne will come back to. These are members of both. Delegate Plum.
Here.
Delegate Corey.
Here.
Delegate Lopez.
Here.
Delegate Rasool.
Here.
Delegate Price.
Here.
Delegate Helmer. Delegate Helmer. Delegate Cole of Fredericksburg.
Here.
Delegate Simons.
Here.
Delegate Jenkins.
Here.
Delegate Wright. Delegate Wright. Delegate Robinson.
Here.
Delegate Wilt.
Here.
Delegate Ferris. Delegate Rush. Delegate Davis.
Here.
Delegate Coinier.
Here.
Delegate Batten.
Here.
Madam Chair, a quorum is present.
Madam Chair, Delegate Simon is here. I'm sorry, I was having a little bit of audio problems. She called the roll.
Thank you, Madam Clerk, and welcome, Delegate Simon. I know you were here. So yes.
Oh, Madam Clerk, Delegate Helmer's here as well. I'm sorry, I don't think so.
All right. Before we begin, I'd like to explain the ground rules for testimony on matters before us today. This committee has a long history of being courteous, respectful, and civil to one another. And while we may have different views on a wide range of topics, we have always maintained a high level of decorum and respect and civil discourse and I expect that this will continue today. To those watching the webcast, I want to thank you for joining us today. We listen to you and we take your views seriously. Your input is welcome and important to us. Viewpoints should be made consciously, concisely, and respectfully, and comments should be directed to the chair. To the extent possible, we have tried to provide for the expression of a variety of viewpoints by balancing the number of speakers in favor and those opposed. I just want to also take a moment to just say a few words personally and how proud I am of the work of the committee. And I certainly want to thank our legislative staff and our tech department and everything because of the hard work of everybody on both sides of the aisle. We had over 1,600 people view us last week. That's pretty remarkable, and I would say that we are making government more accessible to the people. And there is a power of public input. Take, for example, the issue of decertification of police officers and adding to that requirement. The public we saw individually that there are commonalities with the police and our law enforcement officers, every one of them, and advocates. There may not be commonalities everywhere, but we are finding room where we can do some good things for the Commonwealth of Virginia. So for all of us, I just ask that we be brave enough to re-examine ourselves, our criminal justice system, and is what we are doing evidence-based? And will it protect public safety as well as promote the purpose of our justice system? I want to thank again the members of both committees for your hard work and your input, and I'll turn it over to my colleague, Chairman Hope.
Thank you, Leader Herring. It's a pleasure to be with you again today in this setting. Last week, we heard some very compelling testimony from different stakeholders and the public about the need for more transparency in policing and the desperate need to expand decertification and prohibiting a bad law enforcement officer from moving from one agency to another. We also heard about the importance of adequate law enforcement training and also standardized training at the police academies. Today, we will hear from people who are on the front lines that see and experience the injustices of our legal system on a daily basis. We have an opportunity to make systemic changes in our system that has discriminated for far too long. You may disagree that that was ever the intent, but I think we can all agree that that has been the effect. I'm especially looking forward to the testimony of the prosecutors and the defense bar in an effort to seek common ground. What I'm looking to know is what is the most critical things we can do in this special session to begin to make our system more fair and more just. I look forward to today's testimony. Thank you, Madam Leader.
I think my Chairman Hope, thank you so much. And here we go. Our first guest is the Honorable Brian J. Moran, Secretary of Public Safety and Homeland Security.
Good. Well, Madam Leader, chairs, wonderful to be with you. Thank you very much for the invitation. Hopefully the technology is working and you'll be able to hear me and see my presentation. Very good. So there's the presentation, and let's run. Obviously a lot to cover. Spent a lot of time before these two committees during the course of the last couple of years as secretary, and welcome your questions. There is a lot to cover. I'll try to do it quickly, and you can always refer back to the presentation, and then obviously I have a wonderful staff, and you can follow up with any questions you may have that this presentation stimulates. So first, we do have a number of agencies in the Public Safety Secretariat, all of which has been subject of your committee action. Certainly DOC is our largest facility with 13,000 employees, and Harold Clark, well, we are very proud of our recidivism rate. It's been the subject of much conversation with respect to COVID response as well. I will say that as of today, we do have 332 positive cases, and 6 are hospitalized. We've had aggressive testing. We've tested over 28,000. We've performed over 28,000 tests, and that's so important to to address asymptomatic cases so we can take appropriate action to ensure the safety of those in our care. 2 weeks ago, I would have told you we had 16 positive, 16, and we were proud of that. But we've had a recent outbreak at St. Bride's, again, caught because we're aggressively testing. But we got to continue to be vigilant, and like elsewhere in the country and like the Commonwealth, we've seen a bit of a resurgence, and so again, we're well aware of that and working diligently to address it. Next slide, we have DJS. Shannon Dion's doing a great job. So many of the issues you're going to be dealing with respect to training, the 39 various academies, the decertification process will come under her supervision over at DCJS, and so I won't go into that in any depth because I know she testifies a little later, and I'll leave that to her. But they're doing a great job, and we'll need to. She's also doing a lot of test pilots. It's been a wonderful agency to work with. Mental health in our jails, the crime intervention funds that you all appropriated are going through DCJS. So lots going on there, and she'll testify later. Next. So DJJ, again, subject of well, a lot of news recently. We did have 2 escapees, first time in 20 years. They have been apprehended in Michigan, thanks to the police, the state police, and the United States Marshal Service, without incident, fortunately. But we're down. That slide says 157 at Bon Air. We're actually at 150 now. In 1 positive case. After an initial outbreak at Bon Air, we went 2 months from our early May to early July without any positive cases, and then a positive case popped up this month, and obviously keeping an eye on that. But 1 positive case. This is subject to a lot of transformation over at DJJ over the course of many years. We appreciate the legislature's support of those efforts. As you can see by those numbers, we're really decreased intakes into direct care, really reduced from over 600 to down, we're at 150 at Bon Air. So terrific job being done there. Next. VDIM, I'm throwing this in, not so much subject of today's presentation, but I just wanted to throw it out. We do have a new statewide emergency coordinator, and VDIM has just done a phenomenal job with respect to COVID. With respect PPE, personal protective equipment, which rolls off the tongue now after our COVID, our COVID experience. They have distributed 307 shipments of PPE just since July 13th. They've distributed 11 million articles of PPE, which includes about 116,000 PCR tests. So they've just done a terrific job of pushing, appropriating, procuring, and pushing out the PPE. So just wanted to give them a big shout out. And of course, we're in hurricane season. So we've just this Monday, actually Tuesday, we hosted a cabinet exercise, a virtual cabinet exercise with respect to COVID and hurricane preparedness, which obviously complicates things, but we need to be prepared nonetheless, and we will be so. So next. DFS, again, one of our wonderful Secretary Public Safety agencies, back office work, but they just announced, the elimination backlog on rape kits. They just do a great job over there, and give them a shout out as well, Linda Jackson and her team. Next. Fire programs, primarily training, State Fire Marshal's Office. Next. And of course, state police. I know Colonel Settle testified, so I'm not going to spend a whole lot of time on the state police, but they've been supporting over 100 protests. They respond only when requested by a locality, and they've been busy. Next. Parole board, subject to a lot of attention here. Subject of legislation successfully passed by the House, by the way. Thank you. Fishback. They are dealing with the Fishback cases on an expedited basis. I will say, though, they were appropriated you all were kind enough to approve the governor's budget. We appropriated $400,000 to Virginia Parole Board for additional investigators because we are expanding the population of those who are eligible for parole. That money was unallotted because of COVID. So just be aware of that as we push for expedited review of pardons, parole eligibility. They're working diligently over there, but the resources they did not receive because of unallotted funds. Next. ABC, can't forget our wonderful ABC. Travis Hill's doing a great job. And they have been also very much involved in the COVID response. They just pulled 7 licenses down because of the violations of the governor's executive order with respect to bars and occupancy and masks in our restaurant establishments. As you know, based on the governor's press conference yesterday, as of Friday, new regulations will be imposed with respect to alcohol consumption on premises, 10 p.m. last call. And so ABC will be very much involved in its enforcement. So we thank ABC, and they're still doing very well with respect to their stores and in dealing with, keeping their stores open and dealing with COVID and ensuring the safety of their employees as well as customers. Next. Commonwealth Attorney Service Council, in fact, they just hosted training yesterday from prosecutors today. Having been one, always appreciated their continuing legal education courses, always up to date and helping us with the new laws being passed by the General Assembly. So Jane does a great job. Next. This is new, though it was called the Board of Corrections for a long time. Over the last several years, with the legislature's help, particularly Delegate Bell, Senator Deeds, they have been provided additional authority. So just want to put this on your radar as we deal with jails. Again, jails are not under the Secretary's office. They are controlled by locally elected sheriffs. But the Board of Local and Regional Jails, you all renamed it, thank you, because that better identifies what it is they're doing with respect to their role and obligations. This board has been provided additional responsibilities over the last several years, particularly in light of the death of Jermichael Mitchell down in the Hampton Roads Regional Jail. So I wanted to include that. That's subject of additional legislation. We're trying to provide them additional resources in terms of personnel so that they can better perform their new duties. Again, I believe that money was unallotted. So some challenges there, but wanted to, and that's all volunteer. Bernie Francis, he's done a great job. This is just a commission. There's no compensation, but we very much appreciate his and all of the board members' diligence with respect to reviewing and.
Mr. Secretary, I'm sorry to interrupt. We're about out of time. I'm sure there's some more. If there are more about your structural organization, can we sort of speed through those? Because you're almost out of time, and you have a lot of questions.
Well, I did want to get somebody asked about hate crimes. I know we put you can look at that. Virginia State Police does collect data, and that is in the presentation, as well as some of the initiatives we are working on with respect to developing model policies with respect to civilian review boards, decertification process, the 39 academies, but a lot of that will be addressed by Director Dion, and and you can review the presentation at your leisure. We'll forward it along, of course.
Wonderful. Thank you so much, Mr. Secretary. So first in the queue is Delegate Campbell. Delegate Campbell, do you have a question?
Well, I actually did that before this started, but Benji, you called on me. I will ask a question.
Okay.
Secretary Moran, with 4 years as the lowest recidivism rate in the country, why are we changing so much in our correction system? Why are we allowing people out of jail, like convicted police killers and murderers and stuff like that, that are pretty much known to commit crimes again?
Delegate, I had a little bit of difficulty hearing the question, but I believe it had something to do with the releasing violent criminals from our prisons through parole, I believe, or through, through the parole board. So let me just, issues of crime and punishment are always subject to great philosophical debate. I will say the Governor Northam and preceded Governor McAuliffe believed in second chances, and they've appointed parole board members who share those values, and that our prison system is not just created to house people or warehouse people and throw away the key, but rather to try to rehabilitate them. And our corrections attempts to do that through the legislature. We've appropriated funds to provide reentry services, and Harold Clark believes in it, believes in reentry, and that's why we boast a low recidivism rate. I think that's great for the individuals who are returning citizens as well as society, so we don't have any further victims. We don't have a turnstile system in the Commonwealth. People are released, they return to their communities, and they stay there, not come back to prison. So we welcome additional reentry services so that we are just merely warehouse individuals, but rather rehabilitate them. And so we're proud of our system. We can, I think any one of these releases that you've seen from the parole board are defensible. Parole board makes independent decisions, though. The governor appoints, and only the parole board makes those determinations. So if you have an issue on any specific case, happy to forward that along. We'll try to address it. Thanks for the question.
All right. Thank you, Mr. Secretary. Next, I have the Delegate Don Scott. Delegate Scott?
I'm here.
Yes.
Hello. Good morning. Good morning, Mr. Secretary. How are you? Can you hear me?
Good.
Oh, okay.
Yes.
I have some questions. I mean, you kind of went through your organizational chart. I guess what I'm thinking, and I'm trying to hear based on some of the things that are going on now, and I know we're not going to always be as reactive or responsive as we can be when we have to go through the legislature and things like that. Based on what you're seeing out here regarding the police accountability and the impact that policing has had on African American communities, what are you suggesting that we change moving forward? I didn't hear that. I saw a very robust, kind of like I could have went through the Virginia Code and kind of looked at what you kind of presented just now. I want to know exactly what are you doing to respond to the current events that are going on now that folks are clamoring for change. That's one. And then my second question is related to that. I look at your website, because I've requested some information that I've yet to receive. I think y'all said go to the website, so I did. And I see about 382. The legislature gave you the authority to release folks who were within 1 year of release. Now, we're not talking about the, folks that are not about to get out. They were talking about people who are within 1 year of release already, so they're coming home anyway, and that's rotating. And I noticed that we have about 387 folks that have been released according to your website as of July 27th. I've been asking for this information for a while now. What is the total number of people who would be eligible as of July 27th who could have been released? I've yet to see that information. And if you're not reporting that, could you report how many are eligible and how many, based on that 387, how many are eligible and how many have you, and we see you've released 387. So 2-part question. One, that one. And then second, about how many people are eligible in the pool. And second, what are y'all doing differently to respond to the clamor for justice and response to the police accountability, if anything?
We're doing a lot, but let me just address the last point on the.
I didn't see it in your presentation, is why I'm asking.
All right, so Mr. Secretary has the floor.
So I didn't get to get through my entire presentation.
Yes.
Okay. I didn't get through it all, but we are developing. We've reviewed both Virginia Legislative Black Caucus. We've reviewed the Senate Democrats' proposals, as well as working with our own Department of Criminal Justice Services to develop a response. So you'll see responses from the administration that we continue to work on for August 18th, your special session, with respect to decertification, development of model policies for civilian review boards, which localities are perfectly capable of doing now. I think what would be important from the state perspective, like we did with body cameras. Several years ago, I chaired the committee to develop model policies, which subsequently are now every jurisdiction adopting body cameras must have a policy. And DCJS developed that, and I think that's where we should go as well. And we're developing all of those policies, much like you all are. As well as the training, you're going to talk to Shannon Dion about that more specifically. That we have 39 academies, a bit possibly disjointed with respect to quality, and we want to make those uniform and high quality. So,
what about on the justice? What about on justice?
Wait, hold on.
Criminal-
You have a lot of colleagues who want to ask questions. Secretary Moran, if you could finish, and then.
Well, I thought your question was about police reform. On criminal justice, a lot has been done, and we'll continue to work on more. As you well know, this last legislative session was historic with respect to criminal justice reforms. Not only decriminalizing marijuana, but increasing larceny threshold, selling it from 500 to 1,000. Some parole reforms, fishback, finally, after many years of pursuit, we finally got the fishback population eligible for parole. We also addressed juveniles serving 20 years, that they had become eligible after 20 years. We also Delegate Guzman's bill about stopping the juveniles being moved to circuit court and treated as adults, that legislation. So, and driving on suspended licenses, not only court fines and costs, but we also ended the practice of suspending people's driver's license for non-moving violations, which I think was the subject of prosecutor's recent letter. But you did that. The legislature did that this year, effective July 1. So a lot has been done, and we're working through more proposals and want to work with you all, particularly the House and the Senate and the Crime Commission. Further reforms around marijuana, around parole, and around our criminal justice system. Like you, I've been in the criminal justice system since 1989, both as a prosecutor and a defense attorney. So there's some low-hanging fruit. There's other issues that will take some additional deliberation, and I hope you all do deliberate. There's some things we can do, and look forward to working with you, Delegate Scott, and others in the General Assembly. Hopefully we can get some bipartisan cooperation, but if not, there's more we can do, and look forward to working with you on those proposals. So the other issue, though, I do want to address, your other question had to do with the DOC budget amendment. That is an idea we came up with. If you look at the website, there's those who have been released from DOC correctional facilities, which I think you mentioned 382, one from a hospital, and then 193 have been released from local jails. Those are DOC responsible inmates who have been released. So the total number is 581 who have been released. More have been approved, but there's a time lag between approval and the actual release. And as you know, we've discussed this many times. This is a subject of an ACLU suit. There's been a settlement. Court has required certain information to be released, and we're complying with that. And so what all they allow us to release is that number of releases, which is 581. So I'll tell you, 581 people have been released that would not have been released but for this initiative and the legislature's approval. So we appreciate that. So I think that was that number. And I think you asked about how many. That is challenging to the data that much of the data that you have been requesting, and we appreciate it. It's not an unwillingness. Let me assure you of that. One, there's a settlement that we need to make sure the AG's office is okay with us releasing certain information. But the two is just getting the information itself is really the challenge. They have to compute a release date, and that evidently has not been as easy as you or I would think it would be. And that is very time consuming. DOC did not receive any additional resources when we proposed this, and the legislature passed it. They're doing it with the same personnel they had initially. I think they're doing the best they can, and they'll continue to. to do that. So I do not have a number, and it'll be of how many. Well, I'll try. I'll see if, because I think your question was how many as of like today have been eligible but unapproved. We might because I think we have a number that how many have been reviewed, because one, it is the 1 year, but that doesn't mean they're just going to get released. It means, they're prioritizing individuals, and they have to have a home plan. There's a risk assessment. Have they done, re-entry? We want to make sure that they get back on their feet and they have an opportunity to succeed when released. That's, but those who have been eligible and reviewed, that may be a number I could get you. And let me pursue that. Again, it's not an unwillingness. We're not trying to hide the ball in any way. This is brand new to us. We came up with an idea. I think it was a good idea. It's working. And we're just going to have to try to work through it the best we can. So hopefully that
Secretary,
provides some background.
Yeah, we have a lot of other questions that we have to move on. But with respect to Delegate Scott's question, this has been sort of a concern, I will say, from our members about those numbers. So we would appreciate the effort and, for you to get the answer, and we'll provide that answer to all members of the committee. And so for the protocol will be the same for members who did not get to ask a question live here. You could submit the question to Cheryl, who will get it to the secretary, and we will have the secretary will provide the answers, and it will be also made available to the public. Thank you, Secretary Moran. Thank you. Right. Our next witness is Ashley Niels from the Sentencing Project. Ashley Nellis.
And you can take the slide down and show me.
Ashley, please proceed.
Okay, great. Thank you so much. Thank you for inviting me to testify here today. My name is Ashley Nellis, and I'm a longtime senior researcher with the Sentencing Project. We are a national organization that's committed to evidence-based research and advocacy on criminal justice reform issues, and our organization has been a vocal opponent of mandatory minimum sentences since their first endorsement at the federal level in 1986. My comments today pertain to mandatory minimum sentencing here in the state of Virginia. I want to make a few points and would welcome any comments at the end. My first point is that mandatory minimums do not work as they were intended. They have been shown to lack their intended impact as a public safety tool, and they have instead contributed to what we now consider to be a system of mass incarceration. The initial goal of these laws may have been to develop a sense of uniformity across sentences, but this has not been the outcome. We do not have a fair criminal justice system as a result of mandatory minimums. By constraining the ability of judges to use their discretion and to address the facts of a case on an individual basis, what we now have is prosecutors who have this power, along with the incentive to pressure their defendants to accept a plea or face a mandatory minimum. A fair and reliable justice system is impeded by the racial and ethnic bias that tend to drive these decisions. The justification behind mandatory minimums is that if people know that they will face a long time in prison as a result of their crime, they will make the rational choice not to commit that crime. The reality is far more complicated than this. First, this line of thinking assumes that most people are aware of the sentencing structure, which means they would have to be aware of the over 200 mandatory minimum sentences here in the state of Virginia, and that they know, for instance, that by selling an ounce of marijuana to a 16-year-old, a minor, could result in a mandatory minimum of 5 years in prison. The reality is that most people don't think they're going to be caught, as a first point, and they don't think that they don't have a sense of what their punishment will be. The research on the effectiveness of punishment repeatedly shows that it's the certainty of being caught rather than the severity of the punishment that actually makes the difference. The establishment of truth in sentencing and mandatory minimums here in Virginia as well as elsewhere was intended for serious and violent crimes. Can we see the first slide, please? But there has been a trend of incarcerating people for successively lower crimes. Take a look at the state's own data. The largest percentage increase in time served in Virginia between 1990 and 2009 has been for drug crimes, not for violent crimes or for property crimes. The effect this incapacitation approach has not been a deterrent. We can go to the next slide, please. In fact, the dramatic expansion of the prison system has now placed us well past the point of diminishing returns for public safety, affecting sentences from murder all the way to larceny. But most important, we incarcerate people well past the age that they continue committing crimes, as we know that criminal conduct declines with age, and quite precipitously once a person is in their 30s to their 40s. Another problem here in Virginia especially, we can close that slide if you don't mind. Another problem here in Virginia especially is that there are far too many mandatory minimums. Today, as many states begin to rethink their system of incarceration, scale back their mandatories, and depopulate their prisons, Virginia has not taken any of these steps. Virginia is a state, as I said, that maintains hundreds of mandatory minimums, and over 40 of these come about as a result of a nonviolent drug offense. As a result, as recently as 1 year ago, 15 new mandatory minimums that would have had a penalty of life without the possibility of parole were introduced, and fortunately, most of these did not pass. Another point about mandatories is the racial disparity. Racial disparities are well documented, and the dramatic expansion of the prison system over the past 4 decades has had a variety of disturbing effects. It is the disadvantaged communities of color that have suffered the most. People of color, particularly blacks, are overrepresented at each stage of the Virginia criminal justice system. Though they are less than 20% of the general population, blacks are arrested at nearly 3 times the rate of whites. Blacks are incarcerated at 6 times the rate of whites. This expansion of incarceration has also produced a severe imbalance in our approach to public safety, whereby record fiscal expenditures have been targeted at the back end of the justice system through lengthening sentences and filling our prisons. But these come at an expense. These come at the expense of investments in crime prevention, drug treatment programs, and support for effective initiatives to aid law enforcement and courts by promoting a broader public safety strategy. Also, and it can't be avoided, is the issue of geriatric prisoners in the state of Virginia. By its own account, in a recent government report, Virginia has an increasingly costly inmate population that is cause for concern. Costs are accelerating as a result of the aging prison population, and there's no way to look at that a different way. There is also an extremely restrictive compassionate release policy that Virginia stands out as having one of the most stringent release policies for people who are at death's door. If we could show the third slide, please, and this is the final slide. This is from a report from of the Virginia Department of Corrections medical claims data, which shows that the spending for inmates with terminal illness or complex conditions is far higher than the spending for all other inmates. So in closing, I would just like to say that sentencing structures that force judges to impose terms of years based on statutorily mandated minimums have not been demonstrated to be an effective crime control strategy. Instead, they divert funds away from where they have been demonstrated to be effective. They've exacerbated racial disparities. They've contributed to a bloated prison population, and they've placed an unjustifiable financial burden on the state and ultimately its citizens to house individuals in most cases long past what's necessary for public safety. Thank you.
Thank you so much. I will first turn to our members' questions. Delegate Poinier.
Thank you, Madam Chair. Can you hear me?
Yes, I can.
Great. Thank you, Madam Chair. I heard you provide examples of some less serious crimes with mandatory minimums. So I just want to make sure I understand what you're saying. In Virginia, we have mandatory minimums for a variety of crimes, including, I made a list of some that I consider to be pretty serious crimes: assaulting a teacher with a weapon, raping a child aged 12 and under, forcible sodomy of a child aged 12 and under, capital murder of a police officer, repeat offenses, production of child pornography, third violation of protective orders, which we took up issues of protective orders just this year. So is it your position that none of these should have mandatory minimum sentences, the examples I just listed?
It is my position, and that is because those are very serious crimes, and I think that anyone would agree that there is a punishment that should be associated with those crimes. And we have those, all of the things that you mentioned are already illegal, and they're already, there's already a criminal code around them. Just last year, there was a mandatory minimum for killing a police officer. But I'm sure everyone agrees that that was already against the law. I mean, what we don't need is statutory minimums that go past the point of dangerousness. And so it's not an argument that these are not serious. They are serious, and that is why we have judges who decide how to treat the person based on the individual facts of the case and their appearance of redemption and their willingness to reform, which is why they would visit with the parole board every few years and see how that's coming along. Well, this is a system of corrections. The prison is supposed to correct the individual.
Great. Thank you. Delegate Price, you're next.
Yes, thank you for your testimony. It's really interesting, and I wonder if there were any points that you could expound upon, thinking about, from enforcement to the courtroom. Do you have data on how mandatory minimums negatively impact the court's ability to have a sense of transparency, or I guess good relationships with the community? Because I hear from lawyers and I hear from judges, and they feel like even if somebody was found guilty, if they felt like it was a fair trial, then that goes a long way for a sense of justice within the community. And, some people don't understand that the legislature is the one that is imposing that on the judge. Do you have any more to add to just the relationship of how that third branch is able to operate and potentially the negative impacts within the community when mandatory minimums are at place?
I know there's a fair amount of discomfort with mandatory minimums at the federal level, with the judges at the federal level, and that they voiced their concerns about having so many mandatory minimums that really restrict their ability to use their their judicial powers and their skill as a judge. So this also occurs at the state level when a person goes into the courtroom and is given a sentence. The community is affected by that because it's a very cookie cutter approach and doesn't deal with the individual at the at the particular time of the court hearing. They are subject to a series of years, a range of years. A lot of times the judges act, their sentence preference is within the guidelines already.
Great. Thank you. I will now go to Delegate Mullen and then Delegate Miyares.
Thank you, Madam Leader. My question is regards to mandatory minimums. Isn't it a case that right now you're facing a mandatory minimum for the third time you steal a candy bar in a decade, or if you were to throw a snowball at a police vehicle, or perhaps if you were to be driving your vehicle without a license for the third time?
I don't know about the candy bar. I have studied the mandatory minimums that are in the Virginia Sentencing Commission report of last year. So, I think what you describe are things that could fall under a mandatory minimum. I think that that there are a lot of mandatory minimums in the code that could be done away with immediately, and a lot of these pertain to the low-level drug violations. I did see the simple assault on a school teacher was mentioned earlier. That's a 2-day mandatory minimum with a range of 0 to a year. So there's a lot in here where they're really the minimum is kind of bizarre at both ends, right? So it's 2 days mandatory for a teacher, and then several life sentences for a range of crimes that what you described could fall into would be a mandatory minimum.
Madam Chair, one additional follow-up.
Well, it's very briefly, because we have one more. More.
Yes. Isn't it the case that the vast majority of mandatory minimums here in Virginia are nonviolent in nature?
There's 200. Well, there's 40 of the 200 that are drug related. I don't know if it's exactly half that are nonviolent in nature. I know there are many in here that are nonviolent in nature. So it's possible that it's half. I would have to count them, which I could actually do and email your office.
Right, and actually, if you could email the clerk, Cheryl, and we'll make sure you have our information so we can make it available to everybody.
Sure.
Thank you. And then Delegate Miyares.
Yeah, thank you. Question for Ms. Nellis. I mean, to piggyback a little bit what Delegate Conyer pointed out, we're not saying that these cases that involve mandatory minimums aren't already illegal. Obviously, they are. The question is when judges get them wrong, and I'm thinking of particularly the Brock rape. In 2016, you had a Stanford student who obviously came from a wealthy family of privilege, who had tier 1 defense attorneys, who was convicted of 3 counts of rape, took a woman behind a dumpster, raped her, was convicted of 3 felony counts. The judge gave him 6 months in county jail, which meant he actually only served 3. And the judge said that to give him a longer sentence would have, quote, a severe impact on the perpetrator's life, not taking into account at all the victim. And so isn't mandatory minimums about protecting and getting it right when too often, as we've seen, judges can get it completely wrong, not taking into account the trauma that poor woman endured and the fact that this man got out in about 90 days to live the rest of his life. So I'd like to know what you think of that.
I mean, I followed the Brock case closely. It was California, not Virginia. And I was pretty surprised, I guess. Of course, that case got a lot of notoriety because it was considered sort of a white privilege treatment of the crime. And I think, judges usually get it right. I don't know, if I would say that judge got it right, but I would say that by and large, judges do get it right because, I think that in that case, that particular person, and a lot of people with a sex offense conviction, would do a lot better with a way more rehabilitative response to their crime than incapacitative. And I think there has to be both. We can't have serial rapists running around, but we also have to treat them. And most people convicted of a serious sexual assault and crime are not a serial rapist. They themselves were victims first. And there's lots of ways that we can address the conduct that they had, including punishment, but not exclusively punishment and not exclusively removing them from society. I mean, we just probably have a different view on that. But that isn't to say that mandatory minimums are the way to go. You know, I think in the case of Brock, that was a very light sentence. I would be surprised to see a sentence like that here in Virginia, even in the absence of a mandatory.
Oh, and so I'm going to wrap things up. I'm going to take chair's prerogative here and remind and some members don't know, mandatory minimums is being studied at the Crime Commission. It's one of the studies that was approved. But being that said, I do have a question for our guests because I am learning more and more that mandatory minimums are not evidence-based, and evidence has shown actually it does not deter crime. Is that correct?
Are you talking to me?
Yes, ma'am.
Okay. Yes, right. So the evidence is clear and when I say evidence, I mean legal scholars and criminologists who study what happens as a result of these mandatory minimums on public safety. So you look at a state like Virginia, it has a lot of mandatory minimums, right? But it's had a precipitous drop in its crime. So you might say, well, you know, they worked. But there are states that have had far fewer mandatory minimums and also had a precipitous drop in their crime and a precipitous drop in their prison population. Virginia has not had that. It has had the focus on incarcerating its way out of a crime problem, but that was an unnecessary step.
Thank you so much. And I want to remind members, I mean, that's California, Virginia, we elect our judges. And so the other thing is that we have a fix to a judge that would do something that would seem so egregious. So, but I thank you so much for being here and joining us. Next in the queue is Shannon Dion, Department of Criminal Justice Services.
Good morning, Leader Herring and Mr. Chairman. Thank you so much for the opportunity to share information with you today about how training standards for law enforcement officers are developed in Virginia. In the interest of time, I'm going to talk fast, and I'd like to skip to slide 8, please. We're just skipping over slides that give more detail about what the department does in addition to the helping of the training standards. So in this slide, our Division of Law Enforcement is responsible for facilitating any and all revisions to the law enforcement training standards, and I'll explain more about that process in a minute. The division is also responsible for tracking training, certifying and decertifying law enforcement and jail officers, among other duties. We have 6 employees, 3 full-time and 3 part-time, who are responsible for ensuring that criminal justice training academies and agencies are complying with state standards by way of audits and inspections. Next slide, please. These are the agencies that we regulate for compliance with training standards, and as you can see, there are a variety of agencies there. Next slide, please. These are the types of officers that we regulate, with law enforcement being the biggest category. And if you could skip to slide 12, please. This slide is an overview of how training standards are created and updated in the Commonwealth. So state law creates a process by which the Committee on Training is responsible for approving the training standards for law enforcement officers, dispatchers, jailers, etc. And I will tell you who is a member of the COT on the next slide. But what you should know is that the COT doesn't actually draft the training standards. Through regulation, the COT relies on what's called curriculum review committees to do the drafting, and I often refer to them as CRCs. And it's a little bit of a misnomer because they don't actually draft curriculum, but they actually draft the standards. And there are CRCs for each category of professional. So there's a separate CRC for law enforcement, for dispatchers, jailers, etc. And the CRCs work very closely with subject matter experts who are intimately familiar with the various topics that make up the training standards. And I won't go into too much detail on this particular slide about what a job task analysis is, but basically that is an assessment of what the core functions and tasks of any job requires. And DCJS's role in all of this is to help the COT, the CRCs, and the subject matter experts by facilitating the process of setting up meetings, managing the job task analysis, providing information, and capturing the intent of the experts in the drafting and editing phases. Next slide, please. Here is the list of members on the Committee on Training. It's prescribed in the code. About 2 years ago, we did add a citizen member to the board. You will see a lot of different types of stakeholders represented here because in addition to approving the training standards for law enforcement. They also approve training standards for jailers, courtroom security, civil process servers, and the like. Next slide, please. This is the Curriculum Review Committee membership specifically for the law enforcement training standards. There are 9 members on this CRC, and they represent various training academies. Next slide, please. So on the prior slide, you saw that the law enforcement CRC is comprised of academy representatives. And just to differentiate between the Committee on Training from the academies, it's the Committee on Training that says what needs to be taught, and it's the academies who actually deliver the content. So it's up to them to develop their own curriculum and lesson plans and decide how to teach the required standards prescribed by the state. Next slide, please. And I'm just going to go quickly through the academy structure in Virginia. I just want to give you a flavor of what it looks like, but all mandated training for law enforcement officers is provided by an academy, and every law enforcement agency must be a member of an academy. There are 11 regional academies. These are a creation of statute. They are independently operated, and they typically have a board of directors. Next slide, please. There are 28 independent academies, so that makes a total of 39 academies in Virginia that DCJS is responsible for ensuring compliance with the state standards with our team of 6 employees. Not listed on here are the more than 100 satellite facilities that many academies utilize to deliver the training. Next slide, please. And you can see about half of the current law enforcement population attends either a regional or an independent training academy. Next slide, please. Here's just a quick overview of how much general funding goes to support regional academies in addition to the membership fees that they collect. Next slide, please. So by way of comparison to other states with similar populations, Virginia has 39 academies. You can see that that is a number of academies. The states in orange show that these are states that allow some of their law enforcement training to be done through their colleges and/or community college systems. Next slide, please. And here is how Virginia compares nationwide for the numbers of academies. Next slide, please. All right, so the current training standards approved by the Committee on Training require at a very minimum 480 hours of training at an academy. And you can see in the right-hand column that in reality, academies often exceed the minimum by a minimum of 200 hours. And once a recruit completes the basic training and has passed an exam, he or she is then required to complete what's called field training, and that's otherwise known as on-the-job training. And this is a process by which the recruits go back to their agencies, and the agencies basically put them through field training to test them to ensure that they can actually handle the job, that they can apply what they've learned in the academy setting, and comply with the agency's policies and procedures. Now, although the COT has determined that the minimum number of field training hours is 100, you can see that the actual time that agencies put their recruits through does range greatly. Next slide, please. So once officers are certified by the state, they must then continue with training, much like lawyers, doctors, and teachers. They have to get 40 hours of in-service training every 2 years, and the training is determined and delivered by the academies and the agencies. And as you can see, there are 6 hours that are mandatory, that have to cover mandatory subjects. The remainder is left for general career development. And the reason for that is to allow officers to attend a training that enhances their skills in certain ways. For an example, if you have an officer who's gearing up to become a detective, her academy or agency is probably going to want her to take specific classes in developing investigative skills and the like. Next slide, please. All right, just for comparison, here is other states and what they require in terms of in-service hours for the law enforcement officers. It's depicted here in yearly averages. So Virginia is going to show up in green as only having 20 hours per year. That is the median for the nation. Some states require training on in-service training on an annual, biannual, or 3-year cycle. All of the bars in blue indicate states that have specific mandates for what topics must be included in the in-service hours, much like Virginia does. Next slide, please. So I won't spend too much time on this slide, but it is here for your information and reference, but it does detail the number of hours per state and the mandates for the subjects of in-service training. And if you could slide to number 28, please. Okay, so you're probably wondering where we are now with updating the current standards for the next generation of law enforcement. So many updates have been made periodically throughout the years, but a comprehensive review of the entire training standards package has not been done since 1998, which led to this mandate in 2017. And the mandate did require that President Obama's 21st Century Policing Task Force recommendations be included. And as I previously mentioned, the foundation for any training standard for a professional is founded with a job task analysis. So we hired a contractor who provided an independent analysis to help us identify which tasks an officer needs to be able to perform upon graduation from an academy, which tasks are better suited for learning in field training, and which tasks are better suited for advanced training. The contractor also recommended that we use a statewide curriculum given the number of academies that we have. Next slide, please. All right, so DCJS has worked very closely with the curriculum review committees and the subject matter experts to assist them with creating a draft for the new standards. And the process has resulted in some draft language that enhance several areas that are of interest to folks. For example, there is a new performance outcome that's been added that addresses bias-based policing and the negative consequences thereof. And while the current training standards does include this subject, the new draft language provides a lot more detail, a lot more discussion, and includes significant coverage of various types of biases and how to prevent bias-based actions, as well as now requiring recruits to be able to identify and understand the consequences of bias-based policing. There's also been a new standard drafted that requires recruits to effectively identify anti-bias-based policing methods. There's also a new performance outcome dedicated solely to interacting with persons in crisis to include communication skills, de-escalation techniques, and resources that are available to assist the officer. And while all of that information is already included in current training standards, it was not a standalone standard. Next slide, please. So this is our anticipated timeline to complete the process. We were on track before the pandemic hit to finish in March of next year. But before the draft standards are ultimately presented to the Committee on Training for their approval, DCJS is going to share the content widely throughout the state to ensure that communities are engaged and are part of this process. And this is not a mandate for us to do, and I'm not aware of the agency doing this in the past, but we do feel it's imperative that the training standards reflect the public's desires for what the content of future generations of law enforcement are trained on. The bottom line is we want to make sure that this process is very open, very transparent, and that we are seeking input at all levels of the state for the Curriculum Review Committee and the Committee on Training's consideration. Next slide, please. We can advance to the next slide. This is just a reminder that the draft language will go on the Town Hall website. All right, so once there's a draft presented to the Committee on Training for their review and ultimate approval, they have a couple of options before them. One is to flat out reject all the suggestions if they determine that the current training standards are sufficient. The second option is to accept all of the recommendations and approve the draft as it comes to them. Or the Committee on Training could ask for additional work to be done by the CRC, or they could make changes there in their meetings on the fly. I will say that those meetings are public. They're open to the public to attend, and public comment is always welcome. Oops. And next slide, please. This is just a quick summary of where we are in the process. Next slide, please. All right, so let's talk a little bit about current training standards categories. Right now, every officer that has been through an academy and is going through an academy right now will receive training in all 8 of these categories. There are no hourly requirements per category or topic, and each of the 39 academies developed its own curriculum to satisfy the minimum standards. So there is no one standard curriculum taught across the state. Depending on which academy a recruit attends, will dictate which type of curriculum they receive. Furthermore, academies don't have to teach in these categories, just strictly in these categories. So subjects within each category can be interspersed throughout various classes, so long as each category and their topics are covered in the overall training. In fact, many of the themes are interwoven throughout the entire academy curriculum. Next slide, please.
Christiane, just if we could sort of wrap it up, you're a little bit over, and we have questions.
Yes, ma'am. So I will do that. If you just give me a few more minutes, I will advance rather quickly.
Thank
so
you.
The current draft has additional language in there. There are new standalone categories. Next slide, please. Skip this slide, please. Let's talk about decertification. I know you've had some information about decertification. It is dictated by state law. If it's not in the box in front of you, then an officer or jailer cannot be decertified. So there are no statutory grounds to decertify an officer based on ethical concerns. For example, if an officer or jailer is convicted of obstruction of justice or delivering articles to a contraband to a prisoner, that would not qualify for decertification. Next slide. There have been 44 decertifications in Virginia since 2015. Next slide. This is the process. Unless DCJS gets something in writing from a chief or sheriff, we cannot, by law, decertify them. Decertifications are good for 5 years, and the officer can come back to the board and ask for reinstatement. Every decertification that is finalized is entered into this National Decertification Index. Next slide, please. And just to skip back to hiring, the law only requires that agencies do a background investigation, which specifically says must include a criminal history background. So that's the only mandate. There's no mandate to actually go beyond that and do a more comprehensive background investigation, although many agencies do that to include psychological testing, polygraphs, and looking at someone's entire personnel file that may include disciplinary records, the reason for termination, civil complaints, etc. There's no mandate for agencies to ask former employees for this type of information, and no mandate for former employees to actually share that information, even though there's civil immunity. Next slide, please. All right, final observations. Termination is not the same as decertification. DCJS, we do have a database that tracks training and employment, and when an officer separates from an agency or is decertified, that information is entered into our system, but we are not privy to why an officer separates. So if he resigns in lieu of being fired, we are not privy to that information. Next slide, please. And we do participate in the national decertification. Every agency can access this. So far, more than 150 in the state have done that. And next slide. That concludes my presentation, Leader Herring and Mr. Chairman. Thank you so much for your time.
Oh, no, thank you so much. I have one quick question before I turn it over. This is probably one of the most urgent things that we are hearing from people. Officer training, especially de-escalation. I know I put in bills in the past and others. And so my question is on timing. Are we still on course to have something done by March 2021? And then you mentioned that the Committee on Training will have to approve. How long does that take, and what date do you expect that to happen by so we can have new criteria, new training?
Yes, Leader Herring, to answer your question, we could get it done by spring. I would just point out that we want to make sure we do this right and we have enough opportunity to allow for public comment and full digestion of what the curriculum review committees come up with. And so this hasn't been done in more than 20 years. And so while we could certainly push hard to get it done by the spring, I anticipate that there's going to be some dialogue and discussion by the Committee on Training members and the CRC. So allowing time for that, I think by the end of 2021, we could have this finalized.
So a year and a half is what you think?
So I think in about a year, this time next year, towards the end of 2021. It's hard to anticipate how much comment and back and forth there will be between the curriculum review committees and the Committee on Training.
Understand, and I will just say this. I think it's imperative on all of us to make sure that the feet is not dragged and the foot's not dragged on this. Because I will say, members have been trying to put in these bills, and we kept getting, we're working on it, and I'm just here to say that I would like to see a tighter timeline, anything that we can do to make it move faster. And so we're not necessarily rushing, and we're doing it right, but it's way overdue. So I thank you, and I'm going to turn it over to our members, Delegate Bourne.
Madam Leader and Mr. Chairman, thank you, Shannon, for being here. I just want to quickly echo what Leader Herring said. or updated our training standards, and it's going to take another 12 to 18 months. Completely, because the longer we wait, the more pushback, the more slow walking we get, the more Virginia. So that's just sort of an opening comment. My first question is, there was some certification, and you mentioned some things that aren't decertified. So I'd like to ask you, what would you add to the Virginia Code to decertify officers? That's one question. Two, on whether or not we should, because we've heard, there's a patchwork of agencies across the Commonwealth and which standards they're meeting. Should we require one uniform standard in Virginia?
Warren, we're not able to. I'm going to move to the next, Delegate Bourne. I'm going to move to the next member, and then we'll circle back to Delegate Bourne. Actually, I have Delegate Adams, then Delegate Price.
Okay, thank you, Madam Chair. I appreciate that, and thank you, Director, for your testimony. I wanted to follow up with you on a couple of points that was made by Secretary Moran relating to your testimony. We have a special session coming up, and he mentioned that the administration's reviewing proposals. We'll have the administration responses coming soon. And just in terms of what to expect, the Secretary mentioned that he's proud of our best recidivism rate in the Commonwealth. As you know, Virginia's crime rate has gone down even as our population's gone up. I've heard him make comments like that before. I've not heard him say that we need to transform our system or reimagine public safety, but that is what the leadership of this committee has argued. So my question is, in anticipation of what we can expect from the administration, is there a concession that existing policies contributed to our low crime rate, including a lot of what you talked about here in terms of the training that you've overseen, the sort of victim-centric policies that we've had, or does the administration believe we need to reimagine public safety?
Leader Herring and Mr. Chairman, thank you so much for the questions. If I could respond first with the timing, I hear the concerns about making sure that the timing of the standards is a priority. If you could skip back to slide 14, please. I just want to point out that because the way this system is set up in code, DCJS is not actually writing the draft standards, and we are relying on other academy representatives who have full-time jobs to come when they can. So while we certainly understand and want and share your desire to do this process quickly, we do rely on many other players outside of DCJS to do that. I would say, to address some of the other questions, is I think that every system needs examining from time to time to see how it can be improved, and I think that we are at an excellent place right now to examine things in the criminal justice system, and with DCJS's role in facilitating the process to update the training standards for law enforcement. Hopefully you will see the desires of the public and new public policy initiatives reflected in that.
Thank you. Delegate Price.
Yes, good morning, Madam Chairman and Director Dion. I wanted to say thank you for accepting a lot of our input as you've been working, but do also want to add, we had bills that we pulled in 2018, 19, and 20 because we wanted to allow for this process to go forward. But I will just say, it seems like if there's legislation, then that's a mandate for those standards. And I think that's where some of us feel like it is the appropriate time, knowing that we need to get some of this done. But I did have a quick two-part question. One, I saw very quickly that Ohio had a long line or a tall line, and I think it was saying that they had more training. So I wanted to know if you had any data on specific metrics, that the departments that have more training have better metrics like less use of force, better community relationships, no murders, or better de-escalation techniques. If there is an actual data-based correlation between more training and better outcomes, that is my judgment that those are better outcomes. And then lastly, I would just say, I think I saw that some of the additional training was like 40 hours. And I'm just wondering what, in your expertise, do you think is sufficient time to learn nuances, like the spectrum of autism, developmental disabilities versus, let's say, loss of hearing or comprehension issues, as opposed to strict non-compliance? It just seems like 40 hours is not a lot of time to learn a lot of nuances and different things that you would need in order to best perform within the community.
Leader Herring and Mr. Chairman, thank you so much for the question. And as a lifelong learner, I like training. I like to attend training. I can only say that training has a cost required to it. It requires resources and time, and so I think that's from what I hear from folks in the field, that's always the challenge is figuring out that balance. But I would agree that the more training that anyone has, the better that they're going to be at their job.
I'm sorry. Right. I think we're going to have to stop there. I do have to, since my words were invoked, and I feel it is imperative that I respond, because I think we as members, again, I think our challenge is to also, and I know it may be challenging for some, but if we look at that video of the state trooper assaulting and harassing the African-American man in Northern Virginia, you would be blind to sit here and say that our system is okay and nothing needs to change. So I thank you, Ms. Dion, for your work on helping us reform and change the way that we are training our police officers, because what I saw, and this is Charnel speaking independently, is a state trooper harass a citizen. And for any of us to sit here and be quiet and say everything is okay, I suggest that we need to take our heads out of the sand. Thank you, Ms. Dion. Next is Michelle Feldman from the Mid-Atlantic Innocence Project.
Hi, good morning, everyone. Thank you so much for inviting me here today, Leader Herring and members of the committee. I'm Michelle Feldman, and I'm the state campaigns director actually for the National Innocence Project. And we're part of the Virginia Innocence Coalition, along with UVA's Law School and the Mid-Atlantic Innocence Project. And all of our organizations work to overturn wrongful convictions in Virginia and advocate for policies that prevent and address them in the future. So thank you for lawmakers this year working on innocence reforms. It's really been a landmark year. There were improvements to the writ of actual innocence law and requirements for police to record suspect interrogations. And really the next step in addressing wrongful convictions is to rein in the law enforcement abuses that are not only killing innocent people on the streets, but also are taking innocent lives in the courtrooms through wrongful convictions. Official misconduct played a role in half of Virginia's wrongful convictions, and these cases cost taxpayers over $16 million in state compensation and civil payouts. And just two quick examples, the Norfolk 4 case, which is a very high-profile case. 4 innocent men spent between 11 and 18 years in prison for a murder they didn't commit. It was based on police brutally interrogating them until they falsely confessed. And the interrogations were led by a detective, Robert Glenn Ford, who went on to be convicted of federal corruption charges in 2011. And he's involved in at least 4 other innocence cases that are currently being litigated by UVA Law School. And David Boyce spent 23 years in prison for a murder in Newport News that he didn't commit after a police officer lied on the witness stand and withheld critical evidence. And the prosecution also hid a deal given to a jailhouse informant to drop charges in his case in exchange for testimony. So really the first step in stopping this type of police and prosecutor misconduct that was involved in these cases is more transparency. And the Virginia Innocence Coalition recommends the committee consider measures to remove secrecy around police misconduct and investigative files, and also to enhance tracking and disclosure of jailhouse witness evidence. And just starting with the issue of police records, Virginia is one of 21 states where police disciplinary records are confidential, and that increases the risk of wrongful convictions in two ways. First, it allows problematic officers to remain on the force without public scrutiny or accountability. And second, it prevents fair and accurate outcomes in the justice system because prosecutors, defense attorneys, judges, and juries are kept in the dark if an officer involved in the case has a history of abuse. Knowing that an officer has a record of lying on the witness stand, planting evidence, or coercing defendants would have a big impact on judgments about a person's innocence or guilt. So ideally, Virginia's Freedom of Information Act would require public access to police discipline records. Right now, agencies can choose whether or not to release the information, and they almost never do. But short of that, at the very least, the record should be disclosed to prosecutors and defendants through criminal discovery. The new criminal discovery rule took effect this month, but it doesn't address this issue. And knowing that an officer involved in a case has a history of abuses would make a big difference at every stage of the criminal process, from prosecutors' charging decisions to judges setting bail to defense attorneys raising credibility concerns to judges and juries. And finally, convicted people need to have access to their criminal investigative files in their own cases. Right now, if a convicted person makes a FOIA request, an agency can choose whether or not to comply. And many agencies are denying requests. They're citing an exemption in the law for disclosing records in ongoing criminal investigations, even though these criminal cases are closed and the convictions are final. And that's just been a major roadblock for innocence organizations to do their work. And just for comparison, in Maryland, they have a very robust public records law, and it's played a major role in overturning wrongful convictions. Just last November, 3 men who were convicted of a murder in Baltimore and spent 36 years in prison were exonerated because of a FOIA request that uncovered a hidden police report identifying the actual perpetrator. And without that robust public records law, they would still be sitting in prison. Next slide. Thank you. And just to touch on the issue of transparency around the use of jailhouse witnesses. So jailhouse witnesses are incarcerated people who testify against defendants, and they expect leniency or other benefits in their own cases. And that creates a strong incentive for them to lie, and creates an inherent reliability problem. And that's why the U.S. Supreme Court has said that prosecutors are constitutionally obligated to disclose any deals given to jailhouse witnesses, and that is to ensure that judges and juries can consider their motivations and the reliability of their testimony. But in Virginia, at least 3 exonerations involve prosecutors failing to notify defendants about cooperation agreements. And the best solution would be to just stop giving deals in exchange for testimony. That's something that defense attorneys cannot do for their witnesses. But short of that, there has to be greater transparency. So recently, a number of states have adopted laws requiring prosecutors to essentially track the use of jailhouse witness testimony, and also to clarify the exact types of evidence that has to be disclosed to the defense before trial. Connecticut, Maryland, Nebraska, Oklahoma, and Texas all require each prosecutor's office in the state to maintain a central office-wide record of jailhouse witness testimony and cooperation deals. And further than that, Connecticut, Maryland, and Oklahoma require prosecutors to report that information into a statewide tracking system that prosecutors across the state can access. And that allows them to get better information to screen jailhouse witnesses and see if they have a history of giving incentivized testimony in jurisdictions across the state, and if they continue to get leniency, to avoid charges in their own cases. And if the prosecutor moves forward with using the jailhouse witness after having this background, the background information is then disclosed to the defense as part of discovery. Also, Connecticut, Florida, Illinois, Maryland, Nebraska, Oklahoma, and Texas all passed laws that specify exactly when and what types of jailhouse witness evidence must be disclosed to the defense. The new criminal discovery law, the court rule, doesn't address this issue, and it would be really helpful to remove any doubt about exactly what the prosecution has to disclose. So in these states, there are specific requirements that the defense receive access to any deals or benefits that have been or will be offered to the jailhouse witness, the complete criminal history, including charges that are pending or were dismissed as a result of a plea, the substance of the testimony and how the information was conveyed to law enforcement, and the jailhouse witness's history of providing incentivized testimony. And these measures are critical in ensuring that judges and juries know the full background of witnesses when they're assessing their testimony. And it also helps the state to avoid appeals and post-conviction claims alleging that evidence was illegally withheld. So again, I want to thank all the members of the committee and Leader Herring for making this such a monumental year for reforming wrongful convictions. And I really appreciate, again, the opportunity to testify, and I look forward to working on these issues with you all.
I don't see any hands raised. So I thank you so much.
Thank you so much.
All right. Next is Ed Chung from the Center for American Progress.
Good morning, Leader Herring and Chair Hope. Thank you so much, and thanks to all the members of this joint committee for the opportunity to testify this morning. My name is Ed Chung. I'm the Vice President of Criminal Justice Reform at the Center for American Progress. We're a progressive think tank based in Washington, D.C. And I come to this work not only as someone who has developed policing reform policies both in and out of government, especially during the last moment when we as a country were facing policing issues 5 years ago following a series of police violence, including Michael Brown, Eric Gardner, Tamir Rice, and many others. But I was also a former state prosecutor who worked with local law enforcement and a former federal civil rights prosecutor who prosecuted excessive force cases at the Department of Justice in Washington, D.C. So I want to begin by commending Virginia's lawmakers for centering the special session, this upcoming session, on the issue of police reform. The things I've already heard are very encouraging, and I hope that my testimony here adds to that conversation. Let's go to the next slide. The term police reform, however, has a lot of different meanings depending on who you ask. Some like to focus on bad apples and saying that any problems that people have with law enforcement can be cabined off to the few who flout the law or department policies. And while policing, like any other profession, has in its ranks those who intentionally break the rules, it's quite naive and possibly dangerous for policymakers to end the inquiry there. Reforms must focus on transforming law enforcement agency, not just rooting out bad apples. A dysfunctional police department or a police department that hasn't updated police trainings or policies can make good officers do bad things and sometimes unlawful things as well. Police reform to many also means changing trainings and policies, which is incredibly important. And it's a key to the first point of transforming police departments. But there are a number of significant changes that law enforcement agencies must make, and it was encouraging to hear this body looking to mandate de-escalation training and policies during police-civilian encounters, increasing the standards of force, both deadly and otherwise, that can and should be used, meaning that it would be more restrained and restricted, and requiring officers to intervene when they see a fellow officer use excessive force or otherwise commit misconduct or break the law, even if the intervening officer is subordinate in rank to the one violating the rules or the law. These are important changes that I'm sure you'll consider and hopefully enact into law during the special session. Again, however, it is similarly problematic to say that changes to policies and trainings are enough. The aspect of policing reform that is almost always left off the table is meaningful accountability for police officers who violate policies or the law, and also for departments that exhibit patterns and practices of unconstitutional and unlawful policing. Trainings and policy changes are significant, but their impact will not be significant without meaningful accountability measures. Let's go to the next slide. And I want to use an example and focus on the police department that ignited the current movement and protests against police violence. And that's the Minneapolis Police Department in Minnesota. When I was at the Department of Justice, I had the opportunity to head up a national initiative on building community trust and justice between policing and the communities they serve. The core pillars of the initiative were to reduce implicit bias, promote procedural justice, which is the concept that the way police officers treat a civilian during an interaction matters and affects the person's view of the legitimacy of the police and the outcome of that particular interaction, whether it's a traffic stop, a pedestrian stop, or if the person was a witness or a victim to a crime. And the third pillar was racial reconciliation, which is to acknowledge and address the current and historical harms that racial minorities, especially African Americans, experience and that were caused by policing. The Justice Department and our grantees work with 6 police departments, including the Minneapolis Department, to change trainings, hold listening sessions with the community, and institute policy changes. MPD officers all were required to have procedural justice and implicit bias training. And then policies, as you can see from here, an excerpt, policy changes such as de-escalation, duty to intervene, changing the use of force protocols were all enacted. And if you'll notice the part highlighted in green, which is the enactment date of that particular policy that was updated in terms of de-escalation, those things were taking place after the initiation of this and as part of this national initiative. And research from the Urban Institute showed that these changes were making incremental progress in the Minneapolis Police Department's relationship with the communities they serve. So I want to emphasize again that trainings and policies were important. But the question is, why didn't the officers involved in the killing of George Floyd abide by these policies of de-escalation, use of force, and the duty to intervene? So I want to go to the next slide here. One of the enduring difficulties the department and many departments face is the fact that they didn't hold accountable or correct officers for violating policies and trainings. We saw that not only with the officer who was the main perpetrator in the killing of George Floyd, but also as it was a department-wide issue. According to this CNN article that you see, only 1.5 complaints against officers were sustained. And you'll see at the bottom there that law enforcement officials and oversight organizations agreed that this was a low number. It's even a low number compared to the average of percentage of sustained complaints around the country. According to the Bureau of Justice Statistics in the Department of Justice in D.C., about 6 to 8% complaints against law enforcement officers are usually sustained, and that itself is a low number. So what this tells me is that focusing on bad apples and trainings and policies is not enough. It's a systemic problem, not an individual one in many of our departments. And it shows that where departments do not hold up their end of the bargain, they need to be investigated as well. And this is not only fair for the civilians and for the people in the community, it's also fair for police officers. Again, to repeat, we're not talking always about bad apples. We're talking about bad department policies that could cause good officers, well-meaning officers to do bad things or things that violate the law or policies. And so that's why accountability, not only of individual officers, but also of police departments is key. Next slide, please. In keeping with Chair Hope's opening comments, if there was one thing that we at the Center for American Progress would encourage this legislature to consider, it is the third bullet highlighted there, to give an independent agency the authority to investigate police departments for patterns and practices of unlawful or unconstitutional policing. This isn't to say that every department in the Commonwealth should be investigated, or even the majority of them. It's meant for the most serious cases and the cases that show, again, a pattern of unlawful or unconstitutional policing. We're talking about discriminatory policing, uses of force that go unchecked, tactics that are used, whether it's canine, whether it's use of force, whether it's less lethal uses of force, and those are being done and levied against the community and aren't being checked. This authority should also include subpoena authority, as well as accessing data from police departments to analyze patterns of racial bias and discrimination. The investigating agency should also be able to enter into enforceable agreements with the police department to ensure that appropriate changes are made. Now, you may recognize some of this as similar to what the Civil Rights Division of the U.S. Department of Justice has done in the mid-1990s. And contrary to some of the information that's out there, the Civil Rights Division has been very sparing in the department, the number of departments that they've investigated. Some to the dismay of, some. Over the past 25 years, 70 investigations were opened and 40 settlement agreements were entered into. Approximately half of them were court enforced or called consent decrees. And that's because this authority, again, has been used judiciously by DOJ to take on the most serious cases. I will say that in the last administration, the Obama administration, this was paired with another project or an initiative called the Collaborative Reform Initiative, where the Office of Community-Oriented Policing Services took voluntary requests to help departments who saw that they had issues and saw that they had problems, and provided technical assistance and training and oversight so that they wouldn't get to the level of being investigated. And that is also something that this body can consider. As you know, AG Mark Herring, along with 17 other attorneys general, wrote a letter to Congress requesting authority to file suit under federal law against police departments in their state that exhibit patterns and practices of unconstitutional policing. And while Congress continues to deliberate, this body and this legislature should be proactive, just like your colleagues in Colorado. In June, Colorado enacted the Enhanced Law Enforcement Integrity Act and included this very provision to give their attorney general the power to investigate law enforcement agencies. So we encourage this body to consider that seriously as a check, not only for police officers, but especially for police departments. I'm glad to hear that members of this body are considering reimagining or rethinking the role of policing and what public safety means, and consider potentially the size and the scope of responsibilities of the police. For the moment, though, I urge you, again, to go beyond the common notions of policing reform and not stop only at police trainings and police policies, and not only to focus on rooting out bad apples, but to center on police accountability, not only of individual officers, but of police departments as a whole. Thanks for giving me the opportunity to testify. I'm happy to take any questions there.
Thank you so much. You have a lot of people in the hopper. I would ask members only ask one question so that your colleagues can have the benefit of asking a question. Delegate Simon. Delegate Simon.
Madam Chair, I had lowered my hand, but since you called on me very quickly, I will point out. I think I just agree with the issue of accountability, and we did hear. There are more ways to measure public safety than low crime rates, and particularly when many of the victims of some of the violence that they experience, the perpetrators aren't held accountable. There's nowhere to really track those statistics. So I think it's really important that police accountability be a part of this. And we work to change the law enforcement culture overall. And with that, I'll stop and yield to folks whose hands are still up.
All right, thank you. Delegate Levine.
Thank you, Madam Chair, and thank you, Mr. Chung, particularly for focusing on the question of accountability. I've struggled with this question with regards to when there is a citizen complaint. You talked about the fact there's only 1.5% in Minneapolis. And you studied this, how do you balance all these factors that I think we have to weigh when an officer is accused of misconduct? We definitely want due process for the officer. We also want public transparency for the process. There's an ongoing open investigation. There's concerns about witness testimony and the issue of discipline. Do you remove the officer from the force? Are we then saying that problem officers get paid for doing no work? How do we police the investigation? Do you recommend a citizen review board, the attorney general perhaps? so that we get justice for the community, but also due process for the accused?
Yeah, thank you, Delegate, for that question. I think a lot of the answer comes on focusing what the actual complaint is or what the actual issue is. So for something that is, for example, more of a workplace issue, that is something that can absolutely be handled within the police department and so forth. But when we're talking about something that's an interaction gone wrong with a member of the community, again, it depends on the type of interaction it is. The more serious it becomes, the different levels of accountability there is. And I think one of the issues that you're seeing in states across the country is that there aren't many different avenues for this to happen. There may be one, maybe two, and some of them don't have the authority. So the issue with citizen review boards that we have seen is that they don't have the authority, first of all, to either subpoena information and get information, or they don't have the ability to actually have enforce a result. A recommendation may be given, and then it's up to the police department to do with it what they do. And then after that, what the transparency is afterwards. So I think that's a particular issue. When it gets to an even higher level, when it's talking about actual use of force, again, it depends on what that use of force is. If it is something that could be criminal, obviously the prosecutors come in. And here, there's a real question about investigations, whether it should be done by an independent agency at the state level or whether the local prosecutor should do it. If the local prosecutor is going to be the one investigating, what we have seen is that in order to have legitimacy and trust in that process, there has to be an independence within that prosecutor's office to conduct these types of investigations. Otherwise, whatever the results are, they're really going to not have that trust and legitimacy in the community. And then finally, again, if it's a systemic issue, and this is the point that I was raising in the testimony, which is if it's a systemic issue where discipline does not happen, then it's up to an outside agency at the state level, in my opinion, to come in and investigate what the process and the procedure and the system is. When it's a systemic issue that needs to be changed, there needs to be an ability for an outside agency to look at that as well.
If you could give us your recommended structure for that'd be useful. Thank you.
Right. So, members have opportunity for follow-up questions written. I have time for one more question. Delegate Wilk.
Thank you, Madam Chair. Mr. Chung, in your presentation, you talked about the situation in Minneapolis. And so directly looking at that, I mean, we as a society, the whole United States was made very aware that the officer that committed this atrocity towards Mr. Floyd had, 17 or 18? 18. Yeah, 18 against him. But nothing ever. I mean, who was protecting this officer? What broke down in the system? You're talking about outside groups and somebody. You could bring in anyone, but if there's someone there that's going to bat for bad actors, it seems to me like it's all a moot point if someone there protecting him. So could you shed some light on that, please?
Yeah, I think one of the things that we have heard from reports, and again, I'm going by reports on this, especially because my involvement was with the Minneapolis Police Department stopped at a certain point. But in terms of the reports, we're talking about the ability to fire is there if there is something egregious. And most police departments have that. But the question is, what role did the police union have in advocating for this? And what, not only the police union, but what was the arbitration that happened if somebody is fired or somebody is disciplined? And what is that process? And I think this is where trainings and policies do come into play. One of the things that I think one of your previous speakers talked about was the changing of a lot of the trainings in there. And what I encourage you to do is have that training be very as specific as possible, because that's crucial. If you take a look at any of your police department's policies, and when I was investigating criminal cases of excessive force and misconduct, often the evidence that would come in is, well, here's the policy, and there's a lot of this leeway, some of which is necessary for officers to come into play. And so how do you keep somebody accountable for a policy that is not specific and doesn't give clear direction? And again, for this, I think it's incumbent on the department to do that. It's not necessarily something that police officers can do themselves, because they take orders and they take direction. So a shorter answer to your question is the process by which the department has in terms of keeping somebody accountable needs to be looked at. But then whether or not there are other layers on top of that, if it's an outside agency, a civilian review board, or a prosecutor if necessary, or so forth. So whether they have the authority not only to investigate, but also then to push and have their actions and recommendations enacted. I think those are some crucial questions that a lot of police departments across the country and jurisdictions are grappling with and facing.
Right, that's all the time we have for questions. We have to move on. Thank you, Mr. Chung, and I remind members, if you have questions, send them to our clerk, Cheryl, and she'll make sure that it gets to our guests. So thank you again, Mr. Chung. Next is Kim Rolla from the Legal Aid Justice Center.
Good morning, Madam Leader and Mr. Chair. Thank you for the opportunity to speak with you today. As Madam Chair said, my name is Kim Rolla, and I am the Interim Legal Director of Legal Aid Justice Center's Civil Rights and Racial Justice Program. So this morning, my remarks will focus on civilian oversight of law enforcement, which I know this committee will address in more detail next Thursday, August 6th. I'm here speaking with you today mostly due to Madam Leader's scheduling grace, but I also believe that civilian oversight is integrally related to many of the topics that your committees are considering during these joint hearings, and as we heard from just the prior presenter. This is especially true of today's topic of community policing. So community policing it's a broad term with a somewhat amorphous definition, but the approach is typically defined to include, among other things, efforts to increase the flow of information between the community and police, facilitating public involvement in decisions regarding policing priorities, and also an emphasis on hiring officers who are from and live in the communities they police, which you know from presentations last week, many Virginia jurisdictions are still struggling with. So civilian oversight can play a key role in those goals, establishing mechanisms for transparency, creating venues for community input on the scope and form of policing, input which is even more critical when the demographics and backgrounds of law enforcement officers don't reflect the communities that they're patrolling. But my position is that civilian oversight is more than that. It's a seat at the table for conversations that directly impact your constituents' lives. When I think about why civilian oversight is needed, I think of all the stories I've heard while working for police accountability at the local level. To very briefly share just one, it's an early summer evening. A few teenagers are hanging in a car parked outside their house, eating fast food. Several officers approach the car, guns drawn. They order a young man out of the car, and he's immediately handcuffed. The officers order the two young women, stay in the car. When the mom of one of the girls comes home, the officers tell her she cannot approach the car to speak to her daughter. She immediately calls her daughter's cell phone. The cell phone rings. From the sidewalk, mom can see it lighting up in the dark car. But her daughter doesn't answer. It's not until later that mom learns why. Her daughter has placed her hands on the dashboard where the officers can see them, and she's too afraid to take them off the dashboard to answer the phone. This goes on for 2 hours until the police realize they have the wrong teenagers. They take the handcuffs off and walk away, as if no harm done. The crime? A stolen moped. The teenagers? All black, in a rapidly gentrifying neighborhood. I met with the family a few days after, but the daughter didn't want to file a complaint with the police department, a complaint that would only be reviewed by its internal affairs department. She told me, verbatim, nothing will change. I've heard those words countless times. The truth about community policing and many of the policy discussions policy and training discussions we're having is that law enforcement can't have a better relationship with the community until the community has voice and power in how policing functions. And that's why I'm grateful to be here today talking with you about civilian oversight and in the context of this hearing as well. LAJC's police accountability priorities this special session have grown out of deep work with our client community at the local level. In the wake of Charlottesville's deadly Unite the Right rally in August 2017, we helped the community organize for and eventually win the third civilian oversight body in the state. That same year, working with community organizations in Richmond, started fighting for civilian oversight for their police department. Just this Monday, Richmond City Council established a task force of community members to engage their neighbors in designing civilian oversight for my city, Richmond. These years of working alongside community members have taught us invaluable lessons about what local communities need from you, their legislature, in order to provide effective community oversight of law enforcement agencies. The problem is that localities are not currently explicitly authorized by statute to form civilian oversight bodies. These bodies are advisory only. They have no clear mechanism to compel witnesses or the production of documents. Some localities have even questioned their ability to issue unenforceable recommendations on officer discipline. After deep listening to communities engaged in these efforts, our proposed solution is for the General Assembly to pass enabling legislation, giving localities 3 explicit powers to create meaningful civilian oversight. 1, explicitly empower localities to establish these civilian oversight bodies for the purpose of overseeing a law enforcement agency within their jurisdiction. 2, enable localities to vest civilian oversight bodies with subpoena power, which would allow them to compel the appearance of witnesses and the production of documents related to its oversight of a law enforcement agency. 3, allow localities to give oversight bodies final disciplinary authority regarding certain civilian complaints. To achieve this third objective, the General Assembly must also remove certain statutory barriers related to the dismissal, demotion, or suspension of law enforcement officers, which I'm happy to talk about exactly what those are if there are questions. Civilian oversight, when done well, ensures that communities most harmed by destructive policing have direct democratic control over those law enforcement agencies. But localities need you to give them the proper tools. And this is not just a niche issue for a few localities. Over the last 2 months, jurisdictions across Virginia, some of which are represented by committee members here today, have reached out to Legal Aid Justice Center for technical assistance on establishing strong civilian oversight in their own communities. Stafford, Fredericksburg, Fairfax, Henrico, Williamsburg, Alexandria. These are all in addition to LAJC's service areas of Charlottesville and Richmond that I mentioned earlier. And all of them, and likely more, are looking to you for meaningful enabling legislation. And what type of civilian oversight you enable these localities to create matters. An article published in the Public Administration Review by Indiana University Bloomington professors gathered data from 114 civilian oversight agencies in 111 U.S. jurisdictions. They compared what type of oversight was established with reductions in racial disparities in policing over time. Very briefly, because I know our time is limited, there are 3 general models of civilian oversight. A review model, where, as the name suggests, the body reviews complaint investigations that have been conducted by a police department's internal affairs unit. An investigative model, where the body conducts its own independent investigation of allegations of misconduct. And finally, an auditing or monitoring model, in which the body and/or staff analyze data on policing in the jurisdiction. That model may also involve recommending changes to police policies, practices, and training to address any systemic issues that the data reveals. This 2019 study found that all 3 of those models that I just laid out were effective at reducing racial disparities and disorderly conduct stops. The officers chose that as reflective of low-level, high-discretion policing, which you may hear spoken of as broken windows or quality of life policing. As Madam Leader mentioned, this special session's mandate includes addressing the structural racism that lingers in our policing and criminal legal system. So this finding alone supports the General Assembly moving forward on legislation enabling oversight of civilian oversight of law enforcement. But the study also found that only investigative oversight agencies were effective in reducing racial disparities in the most serious uses of force. Specifically, police homicides were what they analyzed. The murder of George Floyd and the outcry across this nation that followed is the reason we are here having this conversation today. And currently, Virginia law makes investigative civilian oversight very difficult because it does not explicitly enable localities to vest civilian oversight bodies with subpoena power. Instead, they're left with only limited workaround mechanisms of compelling witnesses and document production, which severely hinders any investigative work. The General Assembly should act to ensure that all types of civilian oversight are available to localities in Virginia, because localities need these tools to successfully build locally responsive civilian oversight bodies. Another issue that we at LAJC see as deeply connected to our community-driven police accountability work and capable of being addressed in special session is ensuring public access to law enforcement disciplinary records, which another presenter already mentioned this morning. The Freedom of Information Act creates a black box around law enforcement. Due to FOIA exemptions, the public currently has no right to access information regarding if and how law enforcement officers are disciplined for specific instances of misconduct, or to identify law enforcement officers who engage in a pattern of such behavior. Our proposed solution is to strike the current FOIA exemption for law enforcement disciplinary records. This would provide Virginia residents the ability to access critical information regarding law enforcement officer misconduct, It would also allow civilian oversight bodies to access this information without a subpoena. Those civilian oversight bodies could then hold public hearings regarding disciplinary issues, as well as issue public reports on their findings. With that, I'd like to wrap up and reserve my remaining time for questions. Again, thank you for the opportunity to speak with you this morning. I truly believe your committees and your colleagues stand at the threshold of making historic strides towards racial justice and criminal legal system reform. And LAJC is looking forward to working alongside you on these issues in special session and beyond.
Thank you so much. We have time for 2 questions by Delegate Price and then Delegate or Chairman Oak, sorry.
I'm sorry, Madam Leader, did you say I was first?
Yes,
before?
you are first.
Thank you. Thank you for your testimony. I just wanted to contextualize what I was hearing, and I apologize if this is something you can't answer. That's fine. Just let me know. But I'm thinking about the fact that you were mentioning Richmond and what I've been seeing on Twitter and online about the recent protests where peaceful protests are turning violent after use of force from the police department. Is there a correlation between, in your data, between having civilians involved in the process, not just on the back end, but as they're involved in the process, that it has been connected to see departments use less force or have more, I guess, just to be better than what we're seeing on Twitter?
Thank you for the question, Delegate Price. I think that's a really good point, and I went through the models very quickly, but we'll say that the auditing or monitor model does involve both systemic data analysis and then also policy recommendations. That I do like to think of that as being a more front-end intervention, rather than, as you mentioned, kind of waiting for individual allegations of misconduct to look at the broader set of data and then try to create policy, training, practice interventions on the front end that change the data that's coming out. As I actually, after speaking with members of the Senate, looked for literature that analyzed exactly the types of questions you were just asking about what kinds of reductions in racial disparities, like you said, use of force that have been studied in civilian oversight. It's a fairly recent area of scholarship. One of the findings in the President Obama's 21st Century Task Force on Policing, one of the recommendations was actually further quantitative and qualitative study of civilian oversight. There are a number of very good resources that are case studies, but the one that I cited in my remarks is the one comprehensive kind of quantitative analysis that I found, but I'm happy to share more of the case studies with you. I will say, though, that generally speaking, it does. There is a model of civilian oversight that seeks to intervene on the front end, and that has, in some scholarship, been correlated with reductions in racial disparity, as I cited.
All right, thank you. Next, Delegate Hope, and Delegate Hope's.
Thank you. Thank you, Kim, for your excellent testimony. I really appreciate it. In my view, this establishing some enabling legislation on citizen review boards should be the centerpiece of police reform. And I appreciate your testimony. One of the things that I'm struggling with is this concept of permissive versus mandatory. In your opinion, does this need to be mandatory, or can it be permissive to establish these in localities?
I really appreciate the question, Mr. Chair. I think that our position is that the General Assembly should not mandate the creation of civilian oversight in each jurisdiction in Virginia. And the reason is not because we don't believe that that would be a positive development. We believe it's because the best practices tell us that civilian oversight, to be effective, must be built at the local level and responsive to local community concerns, and especially be led by people who have been directly impacted by either over-policing, disparate uses of force. So that is why our suggestion is the enabling legislation. The National Association for Civilian Oversight of Law Enforcement shares this belief that for civilian oversight to be effective, it does need to be highly responsive to the local realities and crafted to address them, and also driven by the community members themselves. So I don't believe that a top-down approach will get the result that this General Assembly is hoping for. I think that ideally the General Assembly would set the table for community members to step up to and then design exactly what their community needs with the tools that you've made available to them.
Thank you so much for joining us and for your valuable information. We do appreciate it. Thank you.
Thank you, Madam Chair.
Next is Camille Cooper with RAIN, and I want the members to know Camille, we're very familiar with Camille, and she's been a great advocate. She has a PowerPoint presentation, but in normal circumstances, if we were in the hearing room, we would ask that children leave the room. And so what she has is something that I don't think is appropriate. Anyone can access our hearings right now. So we certainly want to protect children. So what we will do is make the presentation available to members of the committee. And with that, Camille, I turn it over to you and welcome.
Thank you, Leader Herring and honorable members of the committee. I'm wondering if there's a way we can put the slides up and fast forward through the ones that you feel need to be skipped over. There are some very good, just statistical information at the end of the presentation that would not be disturbing or graphic. Would that be acceptable?
Right. That would be acceptable, but it's impossible for them to do it without the graphic information showing up on the screen. So it's not possible for them to do that. I understand there was a discussion with you last night about it.
No, there was no discussion with me about it.
Oh.
Yeah. No.
So well, we're not able to, because of the graphic nature, this just would be totally, I have no way of controlling, and if they go over it, my understanding is that the graphic material will show. There's no way they can fast forward it without it showing.
Okay. You could just advance to the slide with the statistics on it on the.
What slide number is that? That would be helpful.
1, 2, 3, 4. It's 5 or 6. Slide number 5 or 6.
And statistical information. All right.
Yeah, at that point, it's just statistical. It's not yeah.
Okay.
Madam
And
Chair,
you can start while they're pulling it up.
So my name is Camille Cooper. I am Vice President of Public Policy for RAIN. We are the largest anti-sexual violence organization in the country. We created and operate the National Sexual Assault Hotline. We also do federal and state policy. Today, I'm going to limit my remarks specifically to predominantly mandatory minimums as it relates to sex offenses, and talk a little bit about those crimes to give you a context for why some of those mandatory minimums were established. In the United States, there are right now over 500,000 suspects that law enforcement can see trading images of infants and toddlers being tied up, tortured, and raped. Only about 7% of those suspects can actually be investigated, and that's based on law enforcement capacity issues. In Virginia, in June, 5,114 unique IP addresses were seen trading images of child sexual abuse in Virginia. For 2019, the total was over 36,000 unique IP addresses. Of those, over 2,500 were just sadistic images of infants and toddlers that were seen being distributed in Virginia. Those infants and toddlers were subjected to penetration and torture. I want to talk a little bit about what we know about child sexual abuse material. It's commonly referred to as child pornography, but the field is trying to move away from that to be more clear about what the images actually are. They're crime scene images of the actual sexual assault and rape of children. 84% of the images seen online are of actual sexual abuse. 47% depict extreme abuse, including penetration, bondage, urination, defecation, and bestiality. 56% represent victims that are prepubescent under the age of 12. 4.3% of the images depict infants being sexually assaulted and raped. 92% of the offenders are male. 78% of the offenders are white. Let's pass the next slide. I don't want to get into the next one. We'll go straight to the most widely traded child sexual abuse series relationship. What we know about the relationship between the offenders in these images and the victims in these images is that the majority of the offenders in the images are within a child's circle of trust. 22% are an actual parent, predominantly fathers, that are committing these acts and videotaping them and distributing them. 10% are another relative, like a brother or a grandfather or an uncle. 34% are a close neighbor or a family friend, so someone within that child's circle of trust. And another 10% are babysitters and coaches. The smallest percentage are actually teenagers that are self-producing consensually. We refer to that as sexting, and that's actually a very small percentage of what we see overall online in the images. These offenders congregate online in all kinds of places: chat rooms, news groups, peer-to-peer file sharing networks, Facebook, WhatsApp, Instagram. And they trade manuals, and they teach each other how to identify children that they can victimize, how to groom children, how to penetrate children without leaving injury, and they give each other tips on how to offend. They also give each other tips on how to produce child sexual abuse material, images, and videos online, and how to distribute that without getting caught. If we can move to the dual offender slide, this is where we are just straight now statistics. I think that's like slide 6 or 7. Just skip right to that. What we know about possessors, I think there's a myth about child sexual abuse material possessors, is that they're not dangerous to children and they're not offending against children, and that's not the case. 3 studies that have been done to study this population of offender, and we know that between those 3 studies, 55 to 80% of child sexual abuse material possessors also commit hands-on offenses. There's a recent study done by the U.S. Sentencing Commission, and they looked at age and race of offenders subject to mandatory minimum penalties on these crimes, and what we know is that contrary to a statement earlier that criminal conduct declines with age, that is not the case with sex offenders, particularly offenders that offend against children. What we know is that the largest majority of these offenders, when they're caught, are over the age of 50. The vast majority of them are between the age of 36 and over 50, and you can see that in one of the slides. When we look at race, of these offenders at the federal level, and Virginia's statistics are consistent with this. When we look at the race, you will see that the majority of the offenders are white. About 83% of the offenders are white, even those that are subjected to the federal mandatory minimums. Around 3 to 4% are black, and about 11 to 12% are Hispanic, and then 1 to 2% other. That proportion changes a little bit when you start looking at federal contact offenses, sexual abuse mandatory minimum penalties for offenses against children at the federal level. You'll see whites are still predominantly represented here at 64%, but those ranges expand a little bit for blacks and Hispanics at 19 and 12%. Virginia has mandatory minimums on the possession, distribution. They don't have mandatory minimums on possession. It's reproduction, production, enticement online of children, and then it has Virginia has mandatory minimums for forcible rape of a child under 13, forcible sodomy of a child under 13, and object sexual penetration. I want to make a few distinctions here about these mandatory minimums. For forcible rape of a child under 13, the only way that the mandatory minimum actually applies is if it is alleged in the indictment. So it's an option for a mandatory minimum. It is not a strict mandatory minimum on forcible rape of a child under 13. We have some recent statistics from the Virginia State Police. I'm going to go through a few of these. The mandatory minimums on forcible rape of a child under 13, life. The age of the victim must be alleged in the indictment. As it breaks down right now on the sex offender registry, we have 3 white offenders serving a life sentence for forcible rape of a child under 13. We have 1 unknown and 1 black. So 5 offenses total. So this is consistent with what mandatory minimums are supposed to be used for. They're supposed to be used for the very worst offenders, and when a prosecutor invokes the mandatory minimum on forcible rape of a child under 13, you can see there's only 5 cases. It really is the worst of the worst. I'm going to highlight a few of those at the end of my discussion. For production of child pornography, it's a little less clear statistically. We know that for a child under 15, there is a mandatory minimum, but it only applies if the offender is 7 years older than the victim, and the victim is under the age of 15. Based on the statistics that the state police gave me back, there's no way for me to tell you whether the mandatory minimum was applied in all of these cases. What we know is that for production, there are 304 white offenders that could be subjected to that mandatory minimum on the registry, 3 unknown, 1 American Indian, Alaskan Native, 44 Black, and 1 Asian or Pacific Islander. Those racial proportions are in line with what the population is. And again, I want to have a disclaimer here that the state police was not able to break out of the 353 offenders serving time for production of child pornography of a child under 15, which ones actually did get the mandatory minimum and which ones didn't. So that would need further analysis by the Sentencing Commission, I believe. But you can see that the representations are very different than what you see for other types of crimes like drug crimes and property crimes. The third one I want to go over is online enticement. This is where an offender goes online on Facebook, contacts your child, lures the child to meet the child in a location. A lot of times we think that most of these cases are just law enforcement pretending to be a child, and that is the case in the sort of the Dateline to Catch a Predator stereotype. But I also want to impart to everyone here that there are a lot of children being contacted online every day, and that some of those cases are initiated because a child was contacted, a parent reports it, and then the law enforcement assumes the child's identity to help identify that perpetrator. Those are called online enticement. The mandatory minimum only applies if the child is under 15, the offender is 7 years older. It's a 5-year mandatory minimum. Of the 336 offenders on the registry for that offense, there are 278 white offenders, 6 unknown, 44 Black, and 8 Asian or Pacific Islander. And then there's a second offense mandatory minimum of 1 year for that same type of crime. I'm going to go through a few case studies here of.
Emil, I just have maybe about 3 more minutes because we only need time for questions.
You bet. I'm almost done. I'm almost done. I'm trying to move fast. Okay. 2 offenders I want to highlight that are actually serving life sentences under that mandatory life forcible rape of a child under 13. One is Joe Leake. He was charged with abduction, forcible sodomy, production of child pornography, object sexual penetration, and indecent liberties. His home was stocked with candy, cookies, superhero costumes, and little girls' clothing when they did the search warrant. Because he filmed the rape of the victim under 13, and he was clearly visible in that video, he did receive the life sentence. Raymond Harry is a recent life offender subject to mandatory minimums. He's a white male, and he was convicted of forcible sodomy, rape of a child, 50 counts of production of child pornography. This poor girl, under 12, was brutally tortured in these videos and drugged since the time she was under the age of 10 with both heroin and meth to keep her complicit with these crimes, and she is now trying to overcome at the age of 13 both a heroin and a methamphetamine addiction because of this offender. He was subjected to the life mandatory minimum forcible rape of a child under 13. The last offender I want to highlight is Thomas Jefferson Race. He is a Charlottesville offender, white male. He had, by his own admission, 37 child victims aging between 6 and 11 years old. He subjected his victims to bondage, whips, weapons, including a sword, in order to threaten, coerce, and torture them. He was sentenced before the life mandatory minimum was passed by the General Assembly. He received a 120-year sentence from the judge, of which Judge Hogshire suspended 87 years of his sentence, and he is only serving 33 years. This is a serial offender, lots of child victims, torture, sadistic offenders. So this is what you get when you don't have that life mandatory minimum available as an option for prosecutors to charge under. One thing I do want to state is I received a tremendous amount of data from the state police on Monday. Your problem in Virginia is not with the mandatory minimum statutes on sex offenses with regards to race. The problem is with these statutes where there are no mandatory minimums. The sentencing range can be from 1 year to a life sentence, depending on where the court wants to sentence based on the sentencing guidelines. Just because a statute says the sentencing range is 5 years to 30 years or 5 years to life doesn't mean that's what the court does. The court puts it into the sentencing guidelines and they come up with what they feel is an appropriate punishment based on the elements and the facts of the case. When we did a study of sentencing in 3 reports at my previous job at the National Association to Protect Children, we routinely saw that mandatory minimums were set aside. We saw that jury sentences were set aside. And we also saw a large proportion of judges that mitigate below the sentencing guidelines, which means they're actually sentencing sex offenders to less than what the actual low point is on the sentencing guidelines. So I'm going to recommend that you don't have a problem with racial disparities related to mandatory minimum sentences, but I will recommend that you should look more closely at all of the offenses and do an analysis by county. I think you have some counties that maybe treat things differently than other counties. That's based on the plea agreements, the prosecutor and the judges, and the evidence that they have. And you need to look at that based on census data and look at those proportions there. One thing I also want to mention is that I sat on Governor McAuliffe's Parole Review Commission. We did a lot of great work on that commission, but one thing we didn't study is why cases are coming in disproportionately on certain offenses, and I think that would be a very valuable endeavor for the General Assembly to look at. We looked at sentencing, but we didn't necessarily look at by county, by locality, how those cases are coming in and why they're coming in. And I think that would be a very useful study to do over the next year, maybe with the Sentencing Commission and the Crime Commission. I am open to questions.
Thank you. And we'll just have one question. It's from Delegate Scott, and then we'll go into the public testimony. Delegate Scott, one question from you. And we can't hear you.
I think you're on mute.
Can you hear me?
Now,
Yes.
now we
Okay,
can.
good. I only had one question. When you were speaking about the racial breakdown for a lot of these sex offenses, there seemed to be overwhelmingly 80% high numbers of mostly white males, from what I heard. Is that accurate? Did I hear you correct?
On certain offenses. So on the offenses that are subject to mandatory minimums in Virginia, the offenses where it is, I looked at forcible rape, mandatory minimums. I looked at child pornography production, mandatory minimums, and I looked at online enticement. Overwhelmingly white. And here's why that is, Delegate Scott, because technology and Internet Crimes Against Children task force investigations are predominantly racially blind. When law enforcement gets a tip about an offender, all they see is an IP address. They don't see what the race or the gender or the ethnicity of that offender is. They open the case based on what is the file that they're sharing and what is their IP address. And that's how the investigation starts. We call these racially blind investigations, and that's why you see less of a disproportionate representation in technology-facilitated crimes subject to mandatory minimums.
All right. Thank you.
Thank you so much. Thank you, Camille. It's good to see you, and thank you for being here. Next, we're going to move into the public testimony. I will ask that the speakers limit their comments to 3 minutes. To be fair and respectful to everyone, we will be using a timer, and I would ask that our guests stop speaking when your time has elapsed. To members of the public offering testimony today, please keep your microphone muted until I call you to speak. Please identify yourself, whether you represent a particular group, and please speak for no more than 3 minutes. While I don't anticipate this to be an issue, failure to adhere to any of these guidelines may result in a caller being excused or mute from the meeting. For members of the committee, I ask that you use your raise a hand feature so I can recognize you to speak. But just like last time, I don't think we're going to have time for questions. This is time for the public to speak. 1 moment.
Madam Chair, this is your committee clerk, Cheryl. I believe that we're on the section of the agenda for invited speakers.
I apologize. We are really behind. All right, so we do need to do our invited speakers. Each of these speakers have 5 minutes. Maria Jankowski, Indigent Defense Commission.
Madam Chair, this is Clerk Washana Sr., and we are connecting Maria Jankowski now.
All right.
Yes. Hello. Can you hear me?
Yes.
Thank you, Madam Leader and Mr. Chair, for the opportunity to speak. I'm Maria Jankowski, and I'm with the Virginia Indigent Defense Commission. First, I want to encourage the committee to think big. Moving forward, we have to find ways to both keep people out of the system and help people that are in the system. This current system neither solves problems nor repairs harm. It focuses almost exclusively on punishment, and many folks just want an apology or just help. Despite this, public defenders are always finding help and solutions for our clients. We talk to and we work with victims. We craft out-of-the-box creative solutions. We partner with our community stakeholders to try to find better ways to decrease future harm and help our clients find better lives in the long run. Today, though, I'm going to focus on Commonwealth attorneys and judges. And for those who don't know, the Virginia Indigent Defense Commission, we're the public defenders for Virginia. We need to change the code for more discretion. Often judges and prosecutors will say that their hands are tied. We have to expand the ability to defer and dismiss. It must be expanded as mandatory minimums must be eliminated. I'm going to thank the previous speaker, Ms. Cooper, because I think she makes a lot of my points for me. We're just going to disagree on the solution. Expanding the ability to defer and dismiss will give more avenues for creativity and mercy, but it also has more risk of instances of discrimination. Aside from wealth, the likelihood that you're going to be arrested, released after your arrest, and the final outcome of your case depends more on which jurisdiction you're in and the decisions of those individual actors than any other factor. This can only be changed by capturing and tracking data. As a start, we must start tracking demographic data, specifically race, on the sentencing guidelines worksheets. Our Commonwealth attorneys have tremendous powers. Just as Ms. Cooper pointed out, they can decide who to charge, what to charge, how much to charge, when to charge, and this is so significant because most of our cases are worked out in a plea resolution. Very, very, very few illegal actions are limited to one offense that can be charged. In other words, even when there's a mandatory minimum, that can be embraced by a prosecutor or avoided by a prosecutor. That's all at the discretion of the Commonwealth attorney. Despite this power, Virginia's prosecutors are not required to collect or report any demographic data. The public and lawmakers need to know what decisions are being made. We need to know who's being charged. We need to know who's been given leniency, and we need to know who's not being given leniency. Recently, we surveyed our 330 public defenders. And what we heard over and over again was, and we asked them, what is the biggest challenge in your jurisdiction? And over again, we heard it was the judges. Every single judge brings with them their own unique background and perspective. And the General Assembly has continuously appointed prosecutors as judges. And this is a challenge. More public defenders need to be appointed as judges. And one area where this could make a huge difference is probation violations. Public defender clients are poor. They suffer from housing, job, health instability. Despite all of this, they are almost always ordered into some type of supervision that expects strict compliance. In FY 2020, in the last 5 years, the most frequent type of case handled by public defenders was not a substantive offense, but was an allegation of violating a probation or a suspended sentence. One has to ask how anyone, much less someone struggling with substance use disorder, mental health challenges, housing or job instability, can comply with the 11 standard conditions of probation and the endless number of special conditions that can be placed on someone. Providing people in need of support and services does not have to come with a threat of incarceration if they fall short. Solutions can include capping the amount of time an individual can be placed on supervision, limiting the conditions of supervisions. And our public defenders must be valued. We are understaffed, both relatives to our own needs and compared to the Commonwealth attorneys. We are paid less than the Commonwealth attorneys, and we are grossly under-resourced compared to law enforcement. And we're not afforded the same courtesy and respect by our courts as the Commonwealth attorney and law enforcement. We ask that the General Assembly please consider reallocating some of the positions that were unallotted in the 2021 budget. We need those positions. In closing, I ask you to look at 3 areas. Pre-arrest, we have to end police encounters that further community distrust. This means we have got to stop pretextual encounters. We have to end pretrial detention in most cases. People who are incarcerated prior to trial are more likely to plead guilty just to get out of jail. This is the poor. This gives the rich greater access to due process than the poor. And finally, we have to end the trial penalty. Jury sentencing in Virginia must be only at the request of the accused. And I realize I'm out of time, but I know that's a big topic, and I've covered it all in my written materials that I submitted, and I'm happy to answer any questions.
And unfortunately, we don't have time for questions, but I asked members to submit questions to Cheryl, and we will get them to you. Thank you so much for being here. Next, we have Brian. Thank you. Next, we have Brian Porter from the Commonwealth Attorney's Office.
Bringing Brian Porter into the meeting. Brian, please unmute your microphone.
Thank you. I appreciate the opportunity to speak. Turn the video on here. Thank you, Madam Leader. Thank you, Mr. Chair, for the opportunity to speak this afternoon. I understand that there are a number of speakers still on the agenda, and so I'll keep my remarks brief. I am the elected Commonwealth Attorney for the City of Alexandria. I really appreciate the opportunity to address the committee on such important topics. I can tell you that I, along with a great number of other elected Commonwealth attorneys, see ourselves as leaders in the necessary change that has to be effected in our criminal justice system. And so I'm proud to stand with other elected Commonwealth attorneys to support the really important work that the committee is doing. Obviously, I'm able and willing to answer any questions that the committee might have. I was asked to basically limit my comments today to law enforcement training and maybe very quickly touch on prosecutor training. And I understand that training is not going to be a panacea, and training by itself cannot necessarily change everyone's personality or impact everyone on a very, very decisive level. But I do think training is a very significant part of addressing the issues that exist with racial disparities in the criminal justice system. And I think there are 3 main positives to training. It's obviously, if you train someone, the goal is to affect their behavior and affect the way they approach situations. And so effective de-escalation training, effective training on how to deal with mental health or substance abuse issues is obviously important for law enforcement to hear. But there are other benefits to training that go beyond just that specific hope to change one person's individual capacities or manner in addressing a situation. I think it's also important to note that training inculcates a culture. If rank and file officers are routinely hearing about implicit bias in the system and are routinely hearing about ways to de-escalate encounters as opposed to escalating them, that helps inculcate a culture in which officers are taught the guardian mentality, not the warrior mentality. And while it's hard to adequately and statistically assess how much of a benefit that is, I do think that law enforcement leaders have a duty to inculcate that culture. And one way of doing that is through routine training on these very important topics. And then finally, obviously, everyone would agree that holding officers accountable who do not abide by the rules, who do not comply with the training, and who do not hold themselves out to those very high standards that we expect of law enforcement officers, that's an important part of it as well. And so having this training, going through the training, and making sure that we have records both of what the training was and who attended it can help in that accountability part of the equation as well. It can help in holding officers accountable administratively. It can help when you're determining civil liability with regards to negligence, whether or not training was adhered to. And I can tell you from personal experience, having been asked to investigate several law enforcement involved shootings or uses of force over the years, that looking at the training, looking at the things that the officers were trained and how they either adhered or did not adhere to that training can also be an important part of the criminal equation as well, where necessary. I would also strongly suggest that standardization of training is very important. I am on the board of DCJS, and I heard Director Dion's prior testimony. DCJS does a great job, but the reality of it is one of the issues confronting the American criminal system is the fragmentation of law enforcement agencies. There are so many agencies, and so many of them are very small. They may not have the resources to conduct really robust implicit bias training. And so training does cost money. It costs money to put together the curriculum. It costs money to get the presenters together. And obviously it costs money away from work for law enforcement officers to attend this training. And I would strongly urge the committee to keep that in mind because so many smaller jurisdictions and smaller departments, some as little as 3 or 4 police officers, do not have access to the trainings and the money that's necessary for those trainings that some of the larger departments have. It's really important for the state to kind of step in and make sure that there are minimum standards and minimum training.
Sorry, I just want to let you know about 30 seconds more.
Thank you. Thank you, Madam Leader. I can finish it up very quickly. The 3 main areas of training that I think is important for the committee to consider when it comes to law enforcement: de-escalation. A great example would be crisis intervention training, CIT training. Definitely implicit bias on a routine basis. In fact, I think that should be annual. And I also, as someone who's trained literally thousands of law enforcement officers, they really need to have more of an emphasis on constitutional law. It's hard to adhere to the requirements of the Constitution if you're not really familiar and conversant in those constitutional law precepts. And with that, I thank the committee for the time. I will yield to the next speaker. And obviously, if any committee member has a question, all you have to do is email me. Thank you so much for the opportunity to speak today.
Thank you so much. Appreciate you being here. Next is Christy Wright from the Office of the Executive Secretary.
Bringing Christy Wright into the meeting, and she has a PowerPoint. Ms. Wright, if you can unmute your microphone.
Okay, thank you.
Thank you.
Good afternoon, Madam Chair, Mr. Chairman, and members of the committees. My name is Christy Wright. I'm the Director of Legislative and Public Relations in the Office of the Executive Secretary for the Supreme Court of Virginia. Often called OES, the Executive Secretary's office is the administrative office for the courts in Virginia. We provide assistance to local and appellate courts through our 11 departments, which include, for example, IT, fiscal services, human resources, and as I will focus on today, educational services. Next slide, please. Due to the limited time today, I will touch on only the highlights of the judicial training with an emphasis on bias awareness. However, the presentation that you have contains specifics, including links to many of the resources that I will mention. Next slide. The canons of judicial conduct set forth the standards of ethical conduct for judges. Next slide, please. The canons have broad application from sitting Supreme Court justices to persons who have been selected for a full-time judgeship, but who have not yet taken the oath of office. Next slide. Canon 3 addresses the concept of fairness most directly, quoting, "A judge shall perform the duties of judicial office impartially and diligently." Next slide. Specifically, Canon 3B5 directs that a judge will perform judicial duties without bias or prejudice. Next slide. In addition, Canon 3B6 addresses the judge's responsibility to require all persons who appear in proceedings before the judge to refrain from actions or conduct that manifest bias or prejudice. Next slide. Complaints about a judge that allege misconduct under the canons are handled by the Judicial Inquiry and Review Commission, which is an independent entity created by the Virginia Constitution with members appointed by the General Assembly. Next slide, please. I will now turn to judicial education and its role in providing continuing judicial education, including adherence to the duties required by those canons. A judge's training begins within days of appointment when a new judge is paired with a mentor judge. This pairing provides the new judge with a trusted and trained resource as the attorney makes that transition to a judge. Next slide, please. New judges then participate in a 2-week pre-bench orientation program. In addition to the substantive legal topics, there are 2 75-minute sessions addressing fairness, which include the concept of implicit bias. Next slide. We should be on slide 11. Sitting judges are required to participate in an annual mandatory judicial conference, which is held over the course of 2.5 days. The next 2 slides detail recent courses on implicit bias and inclusion at both the district court and circuit court conferences. Next slide. For judges of the courts of record, there have been 2 trainings in recent years. In 2019, there was a 75-minute presentation on breaking barriers. And also in 2017, there was a 60-minute presentation on implicit bias awareness. Next slide. For district court judges, they had a training in 2016. It was a 90-minute presentation on implicit bias awareness. And then next month at their mandatory 2020 conference, there will be a 75-minute presentation on implicit bias, gender identity, and developing a common language to enable further conversation about systemic racism. That same speaker will also be present at the 2021 mandatory conference and will host a plenary session with a smaller breakout optional session. Next slide. In addition to judges, district court clerks and magistrates have received similar trainings. In 2015, the District Court Clerks Conference included 2 sessions. And then also in 2016, the magistrates held a 1-hour session. Depending on which day the magistrate attended, they would have attended one of those 2. The different instructors were due to availability of those instructors. Next slide, please. And then finally, to better incorporate those topics into our routine and continuing education courses, we're currently looking to, and we're trying to identify a course or a suite of courses for all judicial system employees that would touch on diversity, inclusion, and unconscious bias. That's all of my prepared remarks. I thank you for the opportunity to provide this information to you. I hope the overview was helpful, and I'm happy to answer any questions that I can.
Thank you so much for being with us. We will just go ahead and move to the next speaker. Thank you so much. I appreciate you being here.
You're welcome. Thank you.
Thank you. Next is Brad Haywood from Justice for Virginia.
We're bringing Mr. Haywood into the meeting.
Can you see me? Hear me?
I don't see you yet. Oh, we can hear you, right? There you are. Hi.
Okay.
Welcome.
Good afternoon. My name is Brad Haywood, and I'm the Executive Director of Justice Forward Virginia, and I'll be presenting this afternoon on the topic of pretextual policing. Earlier, you heard from Mr. Chung from the Center for American Progress say that what we're facing isn't primarily a bad apples problem or a training problem. We agree with that. The primary problem that we're facing with our justice system right now isn't that officers don't know that they should de-escalate, that they don't recognize implicit bias, or that they don't know not to use chokeholds. The fact is, as Mr. Chung stated, places like Minneapolis have long ago implemented all of those reforms. And in fact, Minnesota requires more than twice as many training hours as Virginia does. And you also heard from DCJS and also OES now that our academies and judicial training programs already train on implicit bias and other things like de-escalation. If we implement these reforms only, or if we count on them to drive transformative change, the stark racial disparities that we have in our system are still going to persist. There will still be 1 million Black Americans in jails and prisons. There will still be 1.5 million Black Americans on probation or parole. People of color will still be over-policed, and bonds of trust with communities of color will remain broken. The disparities in the use of force, obviously, as I just said, aren't the only disparities in our system. It seems reasonable for me to believe that they are all part of the same problem at the core of our justice system. And for that reason, that's the problem we need to address. We need to address the problem at its foundations. Specifically, as we see it, we need to get rid of the laws that enable police officers to act on their implicit bias or explicit bias, and not just change the manner in which those laws are enforced. Many of these laws that enable policing based on implicit or explicit bias are known as pretexts. Pretextual policing refers to stopping a motorist or a pedestrian for a minor violation of the law in order to conduct an investigation unrelated to the reported reason for that stop. Essentially what it is, it's a cover story. It's a fake reason, you might even call it a lie. And it's to cover for the real reason, which by itself would violate the law. So if a cover story, by the way, if it's good enough and the officer doesn't tell anyone, they can even pull someone over simply because of the color of their skin. They just can't say it. They can't say that the driver looked suspicious or out of place merely because of the driver's race. But some officers do believe that, whether consciously or subconsciously, that a black driver is likely to be committing a crime. Some will pull a car over simply because it is occupied by 4 young black men, because the officer believes that those kids are probably committing a crime. But saying that out loud, the officer believes that young black men are more likely to be committing a crime, that would violate the law. So they have to rely, as I said, on a cover story. Unfortunately, the Virginia Code provides them hundreds of options along those lines, and many of them are absolutely absurd. They serve almost no purpose other than to facilitate harassment or pretextual stops like the ones we're discussing. For example, if you have rosary beads or air freshener or even a handicap placard hanging from your rearview mirror, you can be stopped by a Virginia police officer at any time for having an obstructed view from your windshield. You may have both of your normal brake lights working, perfect working condition, but if that third high mount brake light is out, they have carte blanche to stop you whenever they want. There's something known as license plate tag lights. You may not even know that you had them, but even if your license plate is perfectly visible, just one of those little mini tag lights, even during the daytime, if it's out, police can pull you over. Other reasons include having aftermarket exhaust, dark tint, and of course, I think as a lot of you know, the odor of marijuana. So what happens once a stop is made using one of these pretexts? Justice officers are trained to rely on pretextual stops. They're trained to seek consent to search once a stop has been made. They're taught to create an atmosphere that compels compliance. And in practice, they very frequently get what they want. The surest way to reduce instances of excessive force against Black Virginians is to reduce the ability of police officers to interject themselves in the lives of Black Virginians who truthfully are doing nothing wrong. Think about some of the cases you've heard about: Samuel DuBose, Sandra Bland, Philando Castile. All of them started with a traffic stop of someone who had done little wrong. In the 13 years before Philando Castile was shot to death, he was reportedly stopped at least 52 times, mostly for minor traffic and equipment violations. Eliminate stops for minor equipment and traffic violations. If we do that, that would dramatically reduce the number of unnecessary police encounters. In addition, we could create a suppression remedy for pretextual stops. We could place restrictions on consent searches if a traffic stop is made. If we do that, we'll remove the incentives for pretextual policing. And in doing so, we'll remove a main source of distrust of police among people of color. In conclusion, there's much more to do, but if we're going to get to the heart of the matter, this is where to start, and the time to take action is now. Thank you very much.
Thank you so much for being here. Next is Jamie Walter.
We're connecting Jamie Walter.
I will circle that.
Ms. Walter, if you can unmute your microphone.
Hi, can you hear me?
Yes.
I apologize. So first I'll introduce myself. My name is Jamie Walter. I am a citizen in Powhatan, Virginia. My husband, Virginia State Trooper Special Agent Michael Walter, was killed in the line of duty in Richmond City during a traffic stop. So that's why I feel it's important for me to speak for not only him, but myself and our 3 children. So I appreciate your time today. Just a couple of things I'd like to address is the law regarding changing the assault of a police officer from a felony, to a misdemeanor. I do not believe should happen. And I say that because my husband's murder, while it was capital murder, it was planned, premeditated. His murderer was not held accountable for his actions. It didn't matter his color. Yes, he was black, but that did not matter. What mattered was he murdered somebody, and he was not held accountable. So for me, as a citizen, as an everyday citizen that chooses to do right and to do things that I am supposed to do, I feel like changing this law for our law enforcement not only would be unjust, but then would not hold those accountable for their actions if they are truly doing something that is illegal, and our officers have to take action. Now, with that being said, Mike worked in the poorest of communities because he chose to. And I feel like with what's going on in today's world, my children were never taught to look at somebody's color. They were taught to look at somebody's demeanor. And with that being said, I think there is, and I am a registered nurse and have been for 15 years. And I think in every profession, I think most of us can agree that there are, for lack of a better word, bad eggs, people who do not do the right thing. And so because of actions of some, it's almost an all-out attack on law enforcement. I had to take stickers off my car. I have to take flags down because I have vandalism. And that's not fair to me as a citizen who does right. So how is that fair because of a bad egg who made the majority of our law enforcement officers and their families afraid and now have to defend what they do on a daily basis? I know in Virginia, I can't speak for all states, but I can speak for Virginia, especially the Virginia State Police. They go through a grueling training. They are going in all the time for recertification classes, for updates on laws, for training. I don't believe that it is fair to just focus on our Black community because we all matter. It's not a race or a gender that matters. We all matter. It's not just one race. It's not just one person. It's all of us. And I think changing this law is going to show our children that are growing up and our young adults that they are not going to be held accountable, which is going to send the wrong message. And that's why last year, myself and several other widows, which you're going to be hearing from shortly, we fought and changed laws. And that was Senate Bill 1501 for capital murder of a law enforcement officer, which the minimum was life. The max would have been the death penalty. And then House Bill 2615 for a citizen that is charged with capital murder as well. We have to hold everyone accountable, not just a law enforcement officer and not just a white person. We have to hold all of them accountable because we are all people. We make our choices daily of what we are going to do. If we choose to do good, then that is our choice. If we choose to do bad, that is also a choice. And we can't make excuses.
Ms. Walter, you could wrap up.
I'm sorry.
And if you could wrap up you exceeded 5 minutes, so if you could wrap up, that's all.
I apologize. I'm sorry.
That's all right. That's all right.
I really. So I just believe that changing these laws are going to further allow all citizens to not be held accountable, and I would hope that we would not change this and not make this an all-out attack on our law enforcement, because their lives matter too, both men, women, black, and white. And I appreciate your time, and thank you so much.
Thank you so much for joining. Appreciate it. I did skip over Michelle Demeyer, another invited guest.
Yes, we're connecting her now.
Thank you.
Can you see me, hear me?
Yes, I can hear you.
Okay. How are you? Good afternoon. My name is Michelle Dearmeyer, and I am the widow of Virginia State Police Trooper Chad Phillip Dearmeyer, who was murdered at the Greyhound Richmond bus station, March 31st, 2016. That evening, I had to tell our children, Philip and Paige, who were 14 and 11 at the time, that their dad had been killed at work, and that is by far the hardest thing I have ever had to do in my life. I was completely shocked to hear that there were people in the governing body of Virginia who felt that an assault on a police officer, which is now a Class 6 felony, subject to a mandatory minimum of term of confinement of 6 months, should now be changed to merely a misdemeanor. Clearly, anyone who would think this was a necessary change does not fully understand what it means to be a law enforcement officer. I would challenge each of you to go on a ride along with an officer, specifically in high crime areas, high volume call areas, to know exactly what they face on a day-to-day basis, especially in this volatile and chaotic environment that we are in right now, where blatant disrespect and lawlessness has somehow seemed to be acceptable right now. The proposed idea of defelonizing the assault of a police officer is disrespectful to my husband's life, to the life of Newport News police officer Katie Thine, who was killed January 23rd of this year, leaving behind her 2-year-old daughter, Reagan. Recently in Ohio, Toledo officer Anthony Dia, who was murdered July 4th. And the last words he said across the radio were, "Tell my family I love them." This will embolden an increasing number of attacks on officers, which is already happening, even right here in our state's capital, where RPD officers and VSP troopers have been injured by chunks of asphalt and batteries that have been thrown at them, water bottles with chemical agents that have been thrown at them, all of this occurring at which Mayor Stoney has considered peaceful protests. This short-sighted approach to police reform will not only hurt our officers, but it will put the safety of citizens at risk as efforts to control crime will diminish. What officer will want to be proactive in his or her policing duties, knowing that if he or she were assaulted, that person would essentially be given a slap on the wrist? I have been absolutely appalled at this war on police that has spread like wildfire across our nation. It seems that all law enforcement officers have been unjustly characterized by the abhorrent actions of a few. And enough is enough. Political agendas do not belong in law enforcement. Officer safety belongs in law enforcement. Community safety belongs in law enforcement. Having the best qualified officers with the best qualified, most training belongs in law enforcement. If this war on law enforcement continues, and elected leaders do nothing to support these men and women, the reality is that law enforcement officers will walk away from their profession because it just won't be worth it anymore. The reality is that there will be no one applying for law enforcement positions because honestly, why would you? Law enforcement officers are being vilified by their community and by elected leaders here and throughout this country, and I feel it has to stop now. My sincere hope is that you will support our brave men and women in law enforcement, men and women who see people on their worst of days and try to help them, men and women who have seen horrific things no one should ever have to see, men and women who tell their families goodbye as they head to work and hope that they will make it home safely at the end of their shift. On March 31st, 2016, I said goodbye to my husband, and he never made it home. The pain that our family has endured since that day, I wish on no one. And our family encourages you to stand up and support our everyday heroes, men and women in law enforcement, who risk their lives every single day to serve and protect us. They deserve better. And thank you so much for allowing me to speak today.
Thank you so much for being here, and I appreciate you coming. Next, we will move to our public testimony section. I know that we have gone a little over, but we still have public here, and some have dropped off, unfortunately, but we're going to continue and invite our guests back, the public members who had signed up. Next first is Garnett Robbins-Bauman.
We are connecting Ms. Robbins-Bauman.
Thank you. I'm Garnet Robbins-Bauman, Director of Advocacy at Just Future Project. Just Future Project wants to draw this joint committee's attention to an often left out of the conversation, yet crucial part of community law enforcement, policing on the back end. Policing on the back end is the use of probation and parole as de facto law enforcement for returning citizens living in the community. The destructive force that probation has on the lives of people living under supervision is experienced daily by returning citizens and their families throughout the Commonwealth. This form of law enforcement disproportionately impacts the Black and Latino communities because of their carceral rates per percentage of population. It also disproportionately affects the poorest of Virginians because they are stressed to meet unbearable burdens placed upon them to pay for imposed probation conditions. The most marginalized group in society is always the canary in the coal mine. People, because of the nature of their crime, who are given the label sex offender are, in this society, that group. Whatever the system is doing to these people will bleed into the rest of the carceral population. These people, most marginalized by probation, are registered, tracked with a GPS monitor shackled to their ankles, and in one case to their arm, saddled with unsustainable financial demands, limited by residency restrictions. Employment is controlled by probation, which further forces returning citizens into penury. Above and beyond these untenable conditions, they are subjected to civil commitment, which re-imprisons them after they have served out their sentences for crimes they may commit in the future, to a supposed unaccredited treatment facility, the only DBHDS facility that holds no accreditation, nor can it qualify for one. People convicted of sex offenses are policed with the containment model. The containment model is a perversion of therapy for the purpose of law enforcement surveillance, including forced false incrimination by ordered polygraphs, which are not admissible in court proceedings, yet are routinely used as vehicles to coerce statements from returned citizens that can be used against them to impose severe restrictions, including house arrest, leading up to incarceration through civil commitment in the shadow prison, the Virginia Center for Behavioral Rehabilitation. This is the system currently used in the Commonwealth of Virginia. If you are not familiar with it, you should be. The containment model can be expanded to every other returning citizen. It is literally the exact opposite of the model of community policing and restoration the citizens of Virginia are demonstrating for. The carceral system the Commonwealth is practicing every day is directly opposed to these values. Our citizens of Virginia have demonstrated that time has come to end over-policing in the Commonwealth. Again, probation currently is over-policing at the back end. It is time to reallocate our resources to reimagine what the Commonwealth was intended to be for all of its citizens, especially those most marginalized. What probation is not trained to do is social work, nor are they educated currently to carry out the mandate to foster an environment of successful reintegration into the community. Moving forward, police should police with intelligence and compassion, and if you have not committed a crime, you should not go to jail, period. Probation must be mandated to stop acting as an arm of law enforcement. The Pew
Ms.
Charitable
Roberts, I'm sorry, you're out of time. If you could wrap up, please.
Oh, yeah, sure. There is a new Pew Charitable Trust report that I will make available to everyone. I have two other quick points. 483 persons have been labeled sexually violent predator who have been placed on conditional release in Virginia. Of those, 9 have been charged but not convicted of a new sex-related offense, and only 2 persons have ever been convicted again of a new sexually violent offense, 2 out of 483. These are the new sexually violent offense is defined by the Virginia Code, which is very broad and incorporates 28 offenses grown for the qualifying for. My last point is the Mark Herring. Under Mark Herring, there is a sexually violent predator civil commitment unit whose full-time task is to travel around the state, locking people up after they have completed their sentences. The type of law that this unit is practicing is a human rights and a due process nightmare because they are effectively imposing life sentences for imaginary future crimes. Just Future Project welcomes the opportunity to further this conversation. Thank you.
Thank you so much for joining us. Next is Kenneth Gilliam.
We are connecting Kenneth Gilliam.
Right.
Alrighty. Hello, can you all hear me?
Yes, I can. And Mr. Gilliam, I'll just let you know when you have 30 seconds left, I'll let you know.
Okay.
So you can start wrapping up. Thank you.
Alrighty. Well, first, Leader Herring and Chairman Hope and members of both committees say good afternoon, and thank you all for providing this opportunity for the public to weigh in. My name is Kenneth Gilliam, and I serve as the Policy Director for New Virginia Majority. And so for the sake of time, I will limit my comment just to provide some historical context to policing in the South and the subjugation of Black people, and further then how our history is then connected to the demands for justice and accountability that we're seeing across the nation, but also here in Virginia. So I first want to start with the historical context behind policing in the South. And so as we think about the modern day policing in our country, particularly in the South, a precursor to that were Southern slave patrols, which are actually authorized by county courts to surveil, terrorize, and also maintain Black subordination, which was critical to fueling the early Southern economy, not only in Virginia, but also other parts of the South. Further, we then can look to Reconstruction in the postbellum South also as another entryway to understand how Southern states therefore saw the role of policing, but also the further subjugation of Black people. And so, for example, in 1865, the editor of the Lynchburg Virginian stated that stringent police regulations may be necessary to keep freedmen from overburdening our towns. Magistrates and municipal officers everywhere should be permitted to hold a rod in terrorem over these wandering, idle creatures. And nothing short of the most efficient police system will prevent the utter destruction of our industrial system. And then lastly, as we think about our modern policing system, there have been significant changes that have been made to this system since its early formation, but the vestiges of the past continue to shape the lives of Black people at every entry point in our criminal justice system, particularly as we... Thank you, absolutely. So at every point of our criminal justice system. So just to conclude, here in Virginia, I get to bear witness every day to the work on the ground led by descendants of formerly enslaved people and our allies in the heart of the former capital of the Confederacy demanding transparency, accountability, but also a divestment from a system that has never valued Black lives. So we look forward to working with members of the General Assembly during special session to address the historical and systemic inequities in our policing and criminal justice systems that center the needs of members of our communities throughout the Commonwealth. And thank you for your time.
Thank you so much for joining us and being with us today. Next is Andy Elders.
Connecting Andy Elders.
Thank you.
Can you hear me?
Yes, I can. Welcome. When you have 30 seconds left, I will let you know so you can wrap up.
Thank you, Leader. Thank you and good afternoon. My name is Andy Elders, and I am the Chief Deputy Public Defender for Fairfax County. I'm also a board member with Justice Forward Virginia. I'm here today to say that the time has come to abolish mandatory minimum sentences in Virginia. The first reason is that the threat of mandatory minimum sentences distorts our legal process. Jury trials are now extraordinarily rare. In 2019, in Virginia, only 1.3% of criminal convictions resulted from jury trials. One of the reasons that trials have become so rare is that a prosecutor can threaten a 5 or 10-year mandatory minimum in some cases, while simultaneously offering a shorter sentence as part of a plea agreement. The effect that this leverage has on the accused can be overwhelming. This effect is most pronounced with regard to Virginia's assault on law enforcement statute. Nothing is more important than the ability of someone charged with a crime to say, I did not do this, and I want my day in court. Mandatory minimums are taking that from us, diminishing our criminal justice system and undermining its legitimacy. Second is that mandatory minimums do not reduce crime. As Dr. Nellis testified this morning, evidence demonstrates that mandatory minimum sentences do not have a positive effect on reducing crime. Many states have reduced or eliminated them with no increase in crime. When we adopted these sentences, we effectively said, we'll give up on some people so that we can be more safe. As happens with all Faustian bargains, we did not get what we bargained for, and yet we continue to pay the costs. The third point is that mandatory minimums prevent judges and juries from doing justice. By their very nature, mandatory minimums do not allow for mercy for those deserving of it. Mandatory minimums do not care whether the person being sentenced was mentally ill, desperately poor, or themselves the victims of previous abuse. These sentences are designed to prevent judges and juries from exercising mercy, the instinct not to punish, the instinct that makes us most human. We choose judges and juries carefully, and then mandatory minimum laws force them to ignore their judgment and their humanity, and that is not justice. Finally, these costs are borne disproportionately by people and communities of color. As with every aspect of our criminal justice system, mandatory minimums are imposed disproportionately on Black and brown people in Virginia. People of color are more likely to be overcharged, and they are less likely to be seen as equals by the police, magistrates, and prosecutors who make charging decisions. Virginia is 20% Black, but the prison population is over 50% Black. Mandatory minimum sentences are undeniably a racial justice problem. In closing, thank you, Leader. In closing, we do not need to study these issues further, nor can we pick and choose which mandatory minimums work and which do not. After 25 years of making mandatory minimums the solution to every criminal justice problem, they are everywhere. Their abolition must be a recognition that the benefit of these schemes are illusory and that the cost have become unbearable. Thank you.
Thank you so much for being with us and sharing your comments. Appreciate it. Next is Elizabeth Walker.
Connecting Elizabeth Walker.
Thank you.
Ms. Walker, if you can unmute your microphone.
Is Ms. Walker here? Or she's here.
Okay, she's good.
Madam Chair, would you like us to move on to the next person?
We'll move on to the next one. Thank you. We will now move to Elizabeth Schuster.
Elizabeth Schuster is now in the meeting. Ms. Schuster, if you can unmute your microphone.
Oh, Miss Schuster is not. She here?
She is here. She's in the meeting. Here she comes.
All right.
Madam Chair, would you like us to move to the next person?
Yes, let's move to the next one. Teresa Champion.
Connecting Teresa Champion.
Thank you.
Hi. Good morning. All right.
Hey, welcome. Good morning. I will let you know when you have 30 seconds left, so you can wrap up and you can start whenever you're ready.
My name is, thank you, Leader Herring and Chairman Hope. My name is Teresa Champion. I'm here today on behalf of the Virginia Autism Project. And I want to thank the previous speakers who talked about training and how important that is. And I would encourage the committee and the legislature to request that Shannon Dion instruct that the instruction include training on autism and on special needs and de-escalation. I think that's going to be necessary that instruction is there. I want to speak about mandatory minimums, and in particular with reference to assault on a law enforcement officer. And I want to talk about the people who cannot make the choice. They do not have people with special needs, frequently with autism, do not have the ability to choose how they're going to respond in a situation. I think we're all familiar with research that shows someone with a heightened fight or flight response could be the result of the amygdala being inflamed, other areas of the brain being inflamed, and these people cannot control their response. But sadly, they're charged with a felony, and because of that mandatory minimum, frequently they don't necessarily get bond. We heard testimony that in another hearing that magistrates will frequently not give someone bond if they're faced with a mandatory minimum and a felony. If that occurs to someone with special needs, their social services are at risk. You can't get SNAP, you can't get food stamps, Medicaid waiver, SSI benefits, all the things that are the safety net for this population and this struggling population. So you have a family that is terrified to speak out, quite frankly, about the needs of this population because it might call attention to what they're struggling with. In particular, my son has an autism spectrum disorder along with an autoimmune disorder called Pandas Pans. When we had to call for assistance in a mental health crisis, the police officers tasered him 4 times and he was standing naked on our front porch. So he clearly didn't have a weapon. So he has a tic disorder where he spits on the police. He spits just constantly. He's had that for 10 years. If he spits on a police officer, that's assault. If he scratches a police officer, that's assault. So these people can't necessarily control their response. So we're not talking about we're not talking about decriminalizing this. We're talking about defelonizing. There are other charges that can be brought if a police officer is killed or murdered or maimed in some way in a situation. We're talking
15 seconds left. Sorry.
And thank you. And you've heard from other Commonwealth attorneys who are in support of defelonization also. Thank you very much for this opportunity.
Appreciate you, and thank you for your testimony. Appreciate it. Next, we're going to try again Elizabeth Schuster. I think she's able to connect now.
Connecting Elizabeth Schuster.
Ms. Schuster, are you here?
Ms. Schuster, you just muted your microphone again. Madam Chair, would you like to move on to the next person?
Yes, we'll move on. Ms. Schuster, you're probably like my computer. It takes a while. So just click it once and then wait a few seconds. We have Lynn Van Pelt.
Connecting Jalen Van Pelt.
Hello, my name is Jalen Van Pelt. Thank you for this opportunity.
Welcome, and I will just give you a 30-second warning so you can wrap up.
Perfect, thank you so much. I'm from Alexandria, Virginia. I'm a parent and I've worked as an educator for 21 years. I've seen the direct harm that having school resource officers does to students and the community as a whole. Especially when, like in Virginia, they are required to report felonies that have occurred. If a student made an impulsive decision, even if it causes no harm, is easily resolved, SROs are required to report something as simple as picking up a phone a student finds on the ground as a felony, which can change a child's entire life. Compassionate community policing begins with our children, and SROs have no place in our schools. I'm also asking that the charge of assault and battery of a law enforcement officer be removed from law. It is used daily in the Commonwealth against community members, especially people of color and those with disabilities or mental illness. It is a felony with a minimum required sentence that officers have weaponized against vulnerable populations for years. You see, I'm raising 3 beautiful children, all of which have special needs, 2 African American. My oldest has numerous developmental disabilities. When afraid or when in fight or flight response due to her disabilities, she is incapable of complying to demands or force. Even though she's only 11, I worry every time the police are involved. In the last 2 years, myself or other caregivers have had to engage help with the police 5 times. She spent 6 months of the last year in mental health crisis, and even working with the CSP, Medicaid, and having a crisis team assigned to her, we still had to call the police for help because each time we tried to reach the crisis team first, they could not respond because they were already in the field, and they lacked the funding to have more than 1 crisis intervention specialist on call. Every time the police were called, I feared for my child's life. I worried that the wrong cop would respond and escalate the situation. I worried that a CTU trained officer would not be available to respond. Because when melting down, my daughter panics and she curses and she screams and she kicks and she tries to get away every time if restrained. I should not have to worry that if my child resists restraint as part of her developmental disability, that she will be charged with a felony, as it has been done to many Virginians in mental health crisis, including children. This should be a point of shame for all legislators. And this happens at schools all the time because SROs are there and they view behavior from disabilities through a lens of criminality and are mandated to report any observed felonies, even if a fully trained mental health personnel are appropriately responding. This body has a duty to change this, and I again ask that you work to remove the SROs from schools, advocate to better fund crisis response teams and mental health services, especially for children, and that you abolish Section C that allows officers to charge a felony assault and battery of a law enforcement officer and weaponize this as both a threat and a retaliation. Please, thank you.
Thank you so much. I appreciate your testimony. Thank you for joining us. And I believe that's it. I just want to know from Madam Clerk if Elizabeth Walker is able to join, or Elizabeth Schuster able to connect.
Madam Chair, we're checking on those names.
Madam Chair, Betty Walker is here, Elizabeth Walker, and Elizabeth Schuster.
Right, wonderful. Just tell me which one you will admit to the meeting.
Elizabeth Walker is in the meeting right now.
Okay, thank you. Welcome, Ms. Walker.
Thank you. Can you hear me?
Seconds. Yes, I can, and I'll let you know when you have 30 seconds left.
Okay, that's great. Thank you so much. Good afternoon, Madam Leader and members of the committee. My name is Elizabeth or Betty Walker, and I'm the widow of Virginia State Police Master Trooper Junius A. Walker, who was shot and killed in the line of duty in 2013. During the 2019 General Assembly session, myself and other widows were at the General Assembly in support of Senate Bill 1501 and House Bill 2615, which stated in part that the deliberate and premeditated killing of a law enforcement officer would be defined as capital murder, and that a conviction would result in a minimum mandatory sentence of confinement for life or a maximum of the death penalty. These bills were passed by our governor. My husband was at work nearing the end of his shift on the day that he was killed on Interstate 85 in Dinwiddie County on March 7, 2013. His murderer, who was Black, my husband was also Black. My husband approached his vehicle to see if he needed assistance, and my husband was shot with a .308 assault rifle. As my husband approached the woods trying to get away, the murderer got out of his vehicle and shot my husband 3 more times. My husband protected and served the Commonwealth for 35 years, 35 years of making the Commonwealth a better and safer place in which to live, protecting its citizens and the community. He did not deserve to die so horribly. My husband's murderer received 2 life sentences without parole plus 23 years. But as we've heard from Jamie Walter, her husband's murderer got a ridiculously low sentence, and she got no justice for her husband's murder. All of our fallen heroes who gave the ultimate sacrifice deserve justice. Law enforcement worked tirelessly to uphold the laws that you put into place. We do not need a justice system where any criminal is let back into society after having been convicted of killing a law enforcement officer. That would be no justice at all. It is imperative that justice continue to be served. It must remain in place that convicted offenders get the minimum mandatory sentence of life in prison without the possibility of parole or the maximum of death.
You have 30 seconds.
I thank you for the opportunity to speak today, and thank you so much.
I appreciate you, and thank you for testifying before us today. We're going to try Elizabeth Schuster one more time. Hopefully.
Connecting Elizabeth Schuster.
Hello.
Hi, welcome.
Hi, I'm right here. I'm her daughter. She's coming right in right now, and she's going to begin.
Oh, wonderful.
It took me a while, but we got her headset already, and she has her statement prepared.
Oh, fantastic. Thank you, and welcome,
Yes,
Ms.
of course.
Schuster.
Plug this in, and they'll be able to hear you right away. Put it right. Here you go. Hello. Sit down.
Hi.
Hi,
Welcome.
how are you? Thank you
Good.
so much. And thank you all for your time. I appreciate it so much.
I will give you a 30-second warning when you have 30 seconds
thank
left.
you.
Okay,
All right.
thank
I
you.
live in a household that includes 4 law-abiding, tax-paying citizens of Virginia. 2 of my children, who are now in their mid-20s, were born in Virginia. I no longer want our Virginia taxpayer dollars to be allocated to our failed, archaic system of injustice. That system includes not only the police, it's the lawyers that make money when people commit crimes. That system also includes the lawyers that don't represent their clients zealously, prosecuting attorneys that threaten with plea deals versus a costly trial, and judges who exceed minimums without regard to facts. The current state of Virginia's criminal justice system is at a dangerous crucible. As challenging as it may appear to you, by doing the job you were elected to do, you have the power to start to improve the path that we are all heading in, and it is a slippery slope. Parole needs to be reinstated for violent and non-violent offenders. All offenders that will be released someday, depending on their sentence. Violent and non-violent. The decision to eliminate parole in 1995 was a bad decision. It was thought that by eliminating parole, that it equaled fighting crime. and it did not work. Not only did it not work, it is trending to get much worse. The current path that the Virginia criminal system is structured is not sustainable. Please alter history to improve the future. We can do better, and now is the time, not tomorrow, not next year. Now we are living in extraordinary times which allow for extraordinary actions. Prison is a place for human regression. And without incentivization, inmates are not getting better. It is my understanding that our correctional system is a business model that
30 seconds left.
Okay, thank you. That utilized to justify spending on police, judges, and prosecutors. When someone makes a mistake, they're being given an unreasonable sentences without the ability of parole. The culture of the Virginia court system is to use every tactic in the book to force people unaffordable plea deals to fill the overcrowded jails and prisons, and without that we can say, what are we doing that is not working? And it is not right. I have a son who used a firearm in his own home in a situation in which he believed he was defending himself. Prior to this incident, he had never been in trouble. He received a 10-year sentence for the incident and now is labeled as a violent criminal. He has no ability to reduce that sentence or make parole. He has a nuclear supervisor. He had a nuclear supervisor position at the Newport News shipyard, and he was was attending graduate studies at the College of William and Mary. I support HB 1532 in its original form that Don Scott presented to eliminate.
Wrap up. Your time has expired.
All right. Thank you so much for your time. HB 1532 has to be implemented for all violent and non-violent offenders for it to work. Thank you so much.
Thank you so much. And that will complete our testimony for today. Before we adjourn, I want to turn it over to our clerk for any announcements.
Thank you, Madam Chair. Just a few announcements. The PowerPoints and meeting materials from today have been posted on the meeting website, which is available at studies.virginiageneralassembly, all spelled out, .gov, studies.virginiageneralassembly.gov, and when you get to that page, simply search House Courts or House Public Safety, and members of the public can find all the PowerPoints from today. Madam Chair, written comments for the members of the committee will be open for another week. So we know that some people were in the queue that might not have gotten to speak today or signed up. Written comments are available through the week. Please submit those. Those written comments are distributed daily to members of the committee, and then after the end of the week will be posted on the meeting website. Madam Chair, as you mentioned earlier, if members of the committee had questions for presenters that they didn't get a chance to ask, if they would email those questions to me at cwilson@house.virginia.gov, I will post them to presenters, compile the answers, and send that to members of the committee. And then the last little thing, I think I was able to get attendance for everyone, but may I just double check on one name, and that's Delegate Collins.
So he has resigned. He is now a judge now. So yeah, he will not be there. And Delegate Jennifer Carroll-Foy, she's not sure you all heard her. She is with us.
Yes, ma'am, I got her. Thank you so much, Madam Chair. That completes my announcements.
Well, thank you so much, and I thank the members. Remember, our next meeting is August 6th, a Thursday, not a Wednesday, so I look forward to seeing everyone again, and committee will rise. We're adjourned. Thank you.